All right, Ms. Rivers, are you ready? How are we doing with jurors? Missing three? Does Michelle know who the three are? Great. Okay. Well, let's get on the record. It is Wednesday, the 7th of December, a little after 9 a.m. We are resuming the trial of State of Georgia versus Landon Christopher. We've got our prosecutors here, our defense attorneys, and Mr. Christopher. Good morning to everyone. You all should have received the draft jury charge. I emailed that out this morning. We can talk about that at some point today, depending on how things flow. Mr. Hand, you told us at the close of business yesterday that you had one and a little piece of a witness left. Officer Bath was going to get back on the stand, and then Ms. Newborn. But it's been a night. Has anything changed, or is that still the plan?
Yes, Judge, something has changed.
Okay.
We were able to make contact with and get Ms. Kelly Hooper to appear this morning.
Well, all right.
Ms. Hooper, however, has a complicated schedule because she was not planning on appearing. She would request to give testimony via Zoom, and she would request to do it about 11 o'clock at the court.
Was that demanding witness?
I'm sorry.
No, I don't apologize to me. So she's available virtually.
Yes.
Where is Ms. Hooper?
She's working here in Atlanta. She's at the Home Depot.
Okay. And have you discussed with the defense whether they're okay with a virtual appearance from Ms. Hooper?
I have not, Judge. I just learned recently that she wanted to appear virtual. I know the defense was willing to allow another witness to appear virtual, so.
Okay. So Ms. Wood, this just in, Ms. Hooper is available. Her preference is to appear virtually because of work conflicts. Do you need to confer for a little bit? Why don't you all confer in a moment? Let's just see what else is swirling. Since we don't have all our jurors anyway, you're going to get some time. So Ms. Hooper, still Officer Bath?
Yes, Judge.
Okay, and Ms. Newborn.
Yeah, Ms. Newborn, yes.
And that's your forecast?
Yes.
Okay.
Judge, I just want to remind you that Katie Newborn may testify as a rebuttal witness.
Okay, understood. And it might not be a rebuttal witness. It might be in your case in chief, depending on how things go with Kayla Newborn. You'll have Katie Newborn available?
Yes, Judge.
Okay, understood. Anything else from the state side?
Not that, no, Judge.
Okay. Ms. Wood, how are things this morning?
Good, Judge. How are you?
All right. Other than you wanting to talk with your team and Mr. Christopher about Ms. Hooper, any developments from the defense side? Okay. Why don't you all take a minute while we're waiting on jurors? I'll deal with a couple things and then we'll huddle up about Ms. Hooper.
Thank you, Judge.
You bet. They're here. Fantastic. Okay. Ms. Wood, what is the defense perspective on having Ms. Hooper testify via Zoom?
Well, Judge, if I might, because Mr. Hand said that I had agreed to allow a witness testify via Zoom yesterday. I just want to clarify for the court. We were planning to object to that, but after reviewing the Uniform Superior Court rules on that, it appears that if our objection would have been sustained, the remedy would have been a continuance for the trial.
A remedy could be a continuance of the trial. I don't know that the remedy, but it is a possibility that I could conclude it's essential testimony, so we'll just have to wait till that person can be here, et cetera.
Correct, Judge. So knowing that that would be a possibility, that's why I indicated to Mr. Hand yesterday that we would just go forward and allow that.
That was Sergeant Fortunato,
Correct.
who would have appeared virtually. Okay.
So we are objecting to this witness appearing to do because she wasn't even on their original witness list. And there is a requirement that they be taken notice if they want to appear on Zoom that this is, we would submit she's not vital to the case because she wasn't even on their witness list. She was on ours. So we do object to her appearing via Zoom.
But if she was on your witness list, it's not a surprise that she's involved with the case. Would you have expected the state to agree to having Ms. Hooper appear virtually if you elected to call her and ran into the same situation?
Absolutely not. We were having our investigator bring her
Okay.
forward.
So, Mr. Hand, I understand what Ms. Hooper's preferences are. Has she said under no terms will she be here in person, or that it's preferable? Because another option would be we have her come here after lunch. In other words, you don't have to rest. If we would get to, we're ending a little early for lunch today anyway. And we would just make everyone wait. And then she could get down here and be the witness who appears right after we get back from lunch. So I don't know the dynamic. I know how subpoenas work. So that at least would build in some time to get a subpoena into her hand. It doesn't work real well for the state if a defendant objects to a remote appearance and then the judge says we're going to do the remote appearance anyway.
Well, Judge, even if they were willing to do it for another witness, I mean, it appears that they just don't want the witness to testify versus whether
it doesn't matter why they're objecting. There may be a good faith reason. There may be a tactical reason. It could be a poke a finger in your eye, which they're entitled to do. They don't have a burden. And I just heard Ms. Feely say that the defense objects to Ms. Hooper not being here for the defendant to be able to exercise his right of confrontation. And my understanding of the case law is that it would be error for me over defense objection, not state objection, but defense objection to have a witness appear remotely. It might concern me a bit that this is a witness whose credibility isn't the issue so much. I could see a defense objection to Kayla Newborn appearing virtually. So that all we see is the face and it's harder to confront Ms. Newborn with prior inconsistent statements, et cetera. Ms. Hooper's not that witness. She's going to say what she says about the phone records. But neither you nor I control whether the defense objects. And that's an objection that I think is problematic for the state if I were to overrule it, just because of the confrontation rights that a defendant enjoys in a criminal trial. So I think the ball is back in your court as to ways to get Ms. Hooper here. She may be less happy. My offer was we can be flexible a little bit with the schedule. Again, meaning if it's 11 and we really weren't going to be done yet and you don't have Ms. Hooper yet, but you commit to me that Ms. Hooper would be here after lunch, we'll take a longer lunch break because of a scheduling issue. I'm not going to pin it on anyone. I'll tell the jury, hey, we're going to pause now. We're going to have a longer lunch. And we'll be back at time X. But I'd need to know from you what your investigator has learned about when your investigator can get Ms. Hooper here.
Yes.
You can also continue to talk to the defense and they may withdraw their objection, but that's an objection that I'm inclined to sustain just based on my understanding of the case law. Also open to being educated on the case law. And if you can show me where Georgia appellate courts have said they analyze the nature of the witness where credibility is always an issue. But you understand, I think when I contrast Ms. Hooper with Ms. Newborn, to me, the ability to directly confront Ms. Hooper is less critical than Ms. Newborn. However, it's certainly a little different sharing documents, which is what I think both sides will want to do with Ms. Hooper, the cell phone records, if she is appearing remotely. So I think that is where we are right now. And you and your colleagues can think about different options. It does seem like Ms. Hooper is an increasingly important witness in the minds of at least one juror. So hopefully the drive from a Home Depot in Metro Atlanta to here is something that she can navigate or she can be helped with in an investigator's car. And I'm happy to sign any pieces of paper that would make it clear to Ms. Hooper that being here is not an option, but it's a requirement. And you can pin that on me rather than on your office if that assists.
Yes, sir.
Okay.
Will do.
All right.
Your Honor, an additional observation is that Ms. Hooper apparently has been subpoenaed by the defense because they just commented on how they would cause her to be here if they wanted to call her. And apparently she has not been released by the subpoena. So because she is under subpoena by a party to this case, the state feels that the state ought to as well be able to compel her attendance because she is under subpoena for this case. And she was on the defendant's witness list. They were aware that, of discussions between Mr. Hand and the defense that the state would be calling her or might be calling her. And so the state just observes that she is under subpoena for this case.
Okay. And a valid point. And so all the more basis that someone would have connected with this case to compel Ms. Hooper's attendance. And I was simply adding another layer. I'm happy to also compel it. It is not uncommon for a witness who hadn't been subpoenaed to rise to prominence as a case unfolds. And I don't know that there would be an issue with a subpoena that your office generated today being insufficient to compel her attendance. But I know that a court order would suffice. And I don't mind doing that if that's where we get. But I'll await request from the state side. But I think invoking the defense subpoena would work. Of course, it's a chess match. And I don't know that Ms. Hooper might not get a text in a few minutes saying you are released from the defense subpoena, in which case you're going to need your own net with which to catch her. Okay. Anything else from the state before we bring the jurors in?
Just that would be rather disingenuous of the defense if that were to happen as officers of the court. But,
I agree. But I don't want folks to be relying on something that's not their own subpoena in the end. Who will be first? Is Officer Bath coming in first?
Yes, Judge.
Okay. All right. Ms. Wood, anything else from the defense side?
No, Your Honor.
Okay. Let's bring the jurors in, please.
All right, who's juror?
Thank you, Deputy Gordon. Good morning, ladies and gentlemen. Thanks for coming back. Not that you had an option, but I appreciate that you're here. Hopefully it was a little easier to navigate, get in the building, et cetera. We are ready to continue with the state's presentation in the case of the state of Georgia versus Landon Christopher. We left off yesterday with Officer Ramuno from the Roswell Police Department. I think we're going to start with the reappearance of a witness you heard from yesterday for the state to cover one thing, and then we'll keep moving along. Mr. Hand, are you ready?
I am, Judge.
Great, you can call your next witness.
Judge, the state recalls Officer Sean Bath. Judge, may I approach Ms. Rivers regarding the
Sure.
evidence? Okay.
Welcome back. You thought you were done with us. I'm gonna have you get sworn in again, just because it's been a new day. And then we'll get you going.
You still affirm that testimony you give the truth, the whole truth, that's what you believe? I do. Really, man, have a seat. State your spelling name for the record. My name is Officer Sean Bath with the Roswell Police Department.
Judge, I want the record to reflect, I'm pulling up and sharing a clip from State's Exhibit 6, which is Officer Bass' body worn camera.
Okay, that's already in evidence. And whatever still, it's taken from the video. Have you shared with Ms. Wood the stills you're using?
No, Your Honor.
Okay.
Judge, this is a clip and I have not shared it.
Okay, it's from the video, so that's fine. It's in evidence. I just was curious if this is something Ms. Wood had seen before or not, other than that she's seen the video. So the answer is yes, she's seen it in motion. Okay.
Would you like me to share it? or-
No, I just wanted to know.
Okay, I have labeled the timestamp though,
Okay.
and it does not run afoul of any private.
Oh, so you're actually playing clips. This is not just a still, this is fancy PowerPoint. You're gonna press some button and there's gonna be a video that plays in the PowerPoint. Okay.
And this portion was not covered yesterday, but again, it doesn't run afoul.
Okay.
Judge, we will go with the backup plan and not run it from the PowerPoint,
All right, always good to have a backup.
and run it from the actual thumb drive.
You and PowerPoint haven't had a real good relationship in this trial.
Have not, Judge, unfortunately.
Parked it here when?
This morning,
About what time?
about 10, about 10, 10:30
Okay.
a.m.
And nobody's had really else has the keys to it?
Um,
Sorry, get your flashlight.
what do you?
Does anybody else have a key to it? Or you left it?
I
parked
hope,
it,
I hope,
took the key with you?
I hope they, you know what I'm saying? I hope, and like I told, obviously I be letting my homeboys drive and stuff. I hope ain't nobody double a copy of my key. I hope not. You know what I'm
You
saying?
took the key with you
But
when you parked it this morning?
I don't know. You know what I'm saying? I got the key right now.
Okay,
This
that's
is-
what I'm asking.
Yeah.
Yeah, you have the key with
Yeah,
you.
yeah, I
Okay.
got the key. I got
Yeah,
the
that's what I was asking.
Yes,
When
sir.
you parked it, you took the key with you and left. And
yes, sir.
okay, where'd you go after you parked it here?
Like I said, me and my lady friend, we've been hanging out at her crib while I've been, you know what I'm saying?
Where's that at?
She live in Cumming.
Coming?
Yeah.
Officer Bath, this is a video from your body cam, right?
Yes.
Okay. Was it your understanding that you knew that Mr. Christopher had the only key to his car at that time?
That was my understanding. Yes.
Did you understand that he was not aware of any other person having copied his key to that particular vehicle?
That was my understanding. Yes.
And after this clip, did the defendant after this clip, was the defendant arrested that evening?
No, he was not.
Okay. And he left
He
the
did.
parking lot that night. You all kept the vehicle, correct?
We did.
Did you ever go and physically touch that vehicle?
I did shortly after, or right before, I believe it was right before the tow truck arrived. Sergeant Fortunato had actually walked up to the vehicle and touched the hood. It's something we typically do when arriving on certain calls. We'll touch a hood to see what the temperature may be, how long this person has been here. And when he walked up and touched the hood of that vehicle, it was warm. Often when we do feel something like that, we'll have another officer come over, ask them to touch the hood and see what they think. He asked me to come over and have me place my hand on the hood, and I did notice that the hood was warm.
Did you touch the hood of any other cars in the parking lot?
I cannot say for sure. From my memory, I believe once I touched that hood, there was a black vehicle beside it. And I'm wanting to say that I believe I walked over and touched that, but I do not believe the body cam was on during this time. So I cannot say for definite that that is exactly what I did. I do know I touched the hood of the Toyota SUV, the tan Toyota SUV, and noticed that the hood was warm.
Okay. Was that surprising to you?
It is for it to be a December night and for a vehicle that's been sitting since 10 o'clock that morning.
Were you wearing long sleeves that night?
I was.
Was the defendant, to your knowledge, also wearing long sleeves that night?
He was.
Was he wearing a hat that night as well?
It looked like he had on maybe a boggin.
So what was your opinion of the weather that evening?
Typical December night. It's cooler. We do wear gear that keeps us warm and keeps us extra hot also. So to see an officer in long sleeves lets you know typically that what we're looking at is a cooler night, cooler day.
Would you have expected that vehicle to be cold, the SUV?
Yes.
Nothing further.
Ms. Feely, any questions for Officer Bath?
Yes, Your Honor. Now, on that video, he doesn't actually say that that was his only key, right?
That's not what I heard in the video. No, it's
Right.
not.
And Mr. Christopher wasn't arrested that night because at that point, there wasn't probable cause.
There, at that point to arrest, no, we do not have probable cause at that night. The only thing I was doing in this situation was collecting facts for an investigation.
And you knew that there was another witness on the scene giving the same story, right?
Yes.
And you're familiar with the crime of false report of a crime, right?
Excuse me?
You're familiar with the crime of false reporting a crime?
Yes.
And you've arrested people for that,
I have not.
but you know it's on the books.
Yes.
And you're also familiar with felony false statements?
Yes.
Thank you.
Any redirect, Mr. Hand?
One question, Judge. This parking lot is in Fulton County, is that correct? Is that your
It
understanding?
is correct.
Sure.
All right, go ahead.
I know I said one question, Judge, didn't I? Are you aware of the location where the actual victim, was hit by a car?
It was, if you ask me to walk you out there and put my foot on the ground where it took place, no, I do know it was, I'm trying to get my bearings straight here. It'll be just southwest of the Grimes Bridge Dogwood intersection.
Okay, and is it your understanding that that also was in Fulton County as well?
It is.
Okay, thank you. Nothing further, Judge.
All right, any questions from the jurors for Officer Bath? Take your time. Thank you. Counsel? Officer Bath, do you know if anyone jotted down the mileage on the odometer of the Highlander that night?
I do not.
Do you know if Mr. Christopher, the defendant, was allowed to keep the keys that he had for the Highlander that night?
He was allowed to keep the keys. He was asked if we may have the key to the vehicle, seeing that we were going to impound it, and he chose to keep the key.
Any follow-up to that, Mr. Hand?
Yes, Judge. Officer Bath, did Mr. Christopher keeping his key to the vehicle hinder the police from investigating anything regarding the car?
No, because we would still ask for his permission to search the vehicle. If he did not allow us to search the vehicle, at that point, that's when a search warrant would be obtained.
Thank you. Nothing further, Judge.
Okay. Anything else, Ms. Feely?
Yeah.
All right. Thank you, Officer Bath, for coming back. You are free to go. Is he free to go?
He is, Judge.
All right.
Unless we need him again.
Yeah. All right. Next witness.
Judge, the state calls to the stand, Ms. Kayla Newborn.
Raise your right hand. We swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth so help you. So you will have to see. State your name for the record.
Kayla Newborn.
Good morning, Ms. Newborn.
Good morning.
How are you doing this morning?
Good, how are you?
Good. Ms. Navarre, tell the jury where you're from and where you grew up.
I'm from Cumming, Georgia. I grew up there. I lived in Roswell for a little bit, but mainly Cumming.
Okay. And is your family here? Do you live here alone?
My family lives in Cumming.
Do you live with your family?
I live like kind of between. I just mainly in Atlanta now, but I'm like always in Cumming.
Sorry.
Can you repeat what you
I
just
was
said?
saying, I'm always in Cumming with my parents and my brother.
You're doing fine, but can you just make sure you speak up a bit?
Yes, sir.
Do you know the defendant in today's case, Mr. Landon Christopher?
Yes, sir.
How do you know
I met him back when I was like 14. I was walking around in Roswell and he just walked up.
him? And he walked up and how did he say
Um,
hello? Or-
He walked up behind me and I believe I was walking with my brother and me and my brother just kept walking and he had some guy walk up to me and ask me for my phone number.
And from there, how would you characterize your relationship?
We kind of lost contact for a while and then maybe like around I believe 2019 we got back in contact. We were in a relationship, you could say.
Okay. And if you want to step back, are you currently employed?
Yes, sir.
What do you do?
I'm a nanny for a little boy with disabilities and I clean houses and I dog sit on the side.
And in December of 2020, what was your occupation at that time?
I was cleaning houses for the company Mary Maids.
And when you say cleaning housing, that just means like, they hire you to.
Right, they hired me. We drove our own vehicle and we would get like maybe 3 or 4 houses a day and just go to each house, clean them up.
And was this just with colleagues, with family?
Back then, that company, they specifically did just, it was just like a random company I found, but they did, like we just went in by ourselves. We didn't have a teammate or anybody.
Okay. And did you graduate high school or get any further education?
I graduated high school in Cumming and then I went to college for a little, I want to say about a month. I went to North Georgia Technical College.
What you go to college for,
I was doing hair.
but you didn't complete?
No, sir.
Did you enter any other technical program after that?
No, sir, I didn't.
So in December of 2020, what was your relationship at that point with the defendant?
So I believe the end of 2019 is whenever we kind of ended things. And then 2020, from what I remember, I hadn't really had much contact or spoke to him that much that year. I had a boyfriend at the time. And we came into contact the day of the incident in December 2020.
Why did y'all come into contact? And what day was that? Do you remember?
I believe it's the 12th
Okay.
or the 11th. I think the night of the 11th.
11th or 12th that evening?
Yes, sir.
Why did y'all connect? Yeah.
Like I said, I had a boyfriend that year and we had just went through a breakup that day. And so I had called him so I could just have somebody to talk to.
Okay. And when you called him, what did you agree to do with him that day, if anything?
We just were meeting up just to talk in general.
Okay, so where did y'all agree to meet up?
We agreed to meet up at a gas station that was nearby on exit 7, I believe, in Roswell.
What type of gas station? Do you remember the name of it?
I believe it was a QT or a racetrack. I'm not sure.
Okay. And while you were at the QT, did you get anything from the store?
I don't believe I went in the store. I parked my car on the side of the gas station. He had parked at a gas pump and I got in with him.
Do you know if he got anything from the gas station?
I can't remember. I don't know.
Okay. Did you take anything with you? Well, so he parked at a pump?
Yes, sir.
Parked on the side of the building.
Yes, sir.
Who from there went after?
I got out of my vehicle and I had a bottle of Jack Daniels I had brought with me. I brought it into his vehicle. with me.
Where did the bottle of Jack Daniels come from?
I had it prior to coming to meet up with him for my boyfriend's house when I grabbed all my stuff and I was leaving. Or ex-boyfriend, but
Okay, so if I'm understanding you correctly, the bottle of Jack Daniels came from your ex-boyfriend's house.
yes, sir.
Okay, what was his name?
Jermaine.
What size bottle?
I believe it's the 750 milliliters, one of the bigger ones.
Okay, and if you could gesture, show how tall you think it is.
Probably about like that.
Okay. And about how wide?
Like this maybe.
Okay. So you took that with you. Had you drank any of it before you got into?
No, it was still sealed.
Okay. So you got into the defendant's vehicle. What
Yes, sir.
type of vehicle did you get inside of?
I believe it's a Toyota Highlander. It was like goldish in color.
Okay. And you took the bottle with you. Was the bottle ever opened inside the vehicle?
It was eventually opened in the vehicle, yes, sir.
Okay. And who drank from that bottle?
Both of us did.
Okay. Did y'all mix the Jack Daniels with anything?
I don't remember if we mixed it, but I believe we may have chased it with Coca-Cola.
You know where the Coca-Cola would have come from?
No, sir. I don't remember, sorry.
Was it in the vehicle when you entered the vehicle?
I don't remember bringing one, so I don't know if he already had a Coca-Cola or if maybe like at some point a Coca-Cola was picked up like from a store. I don't remember.
Okay. So the seal's broken and both of you drink from it. And about how much would you say you drank versus the defendant?
I could just guess saying maybe half. Because we would take turns drinking it, so I believe it would probably be half and half for each of us.
When I'm referring to the defendant, is that person in this room right now?
Yes, sir.
Can you point him out and describe a particular article of clothing that he's wearing?
He's sitting over there wearing a gray jacket.
Your Honor, say what, like for the record to reflect that Ms. Newborn has identified the defendant at different stages.
She has?
Where did you all go, if anywhere, from that gas station?
We just drove around like Roswell and Atlanta area for the most part. Just kept driving a lot. We did, I believe we went down to Atlanta and we had picked up some drugs from Atlanta.
Who's driving the car?
Landon.
Do you ever at any point that night drive the car?
No, sir.
Had you ever seen this car before?
No, sir.
I may have missed it. Did you already describe what kind of car it is?
Yes, sir.
And what was that?
It was a goldish Toyota Highlander.
Okay.
You said, so, if I heard you correctly, you said you went to pick up drugs.
Yes,
right?
sir. Yes, sir.
Can you describe for the court what type of drugs?
It was cocaine powder.
Did you use cocaine before?
Yes, I had. Yes, sir.
Do you know if the defendant has used cocaine before?
Yes, sir.
Y'all used cocaine together before?
Yes, sir.
Y'all used cocaine and alcohol together before?
Yes, sir.
How many times in the past have y'all done this?
I'm not exactly sure how many times, but it's been a few times.
Okay. This location where you picked up drugs, where was it?
It was in Atlanta, I believe.
You know, what type of structure?
It was like a house, like a kind of rundown house.
Did you enter the house?
No, sir.
Where were you when the securing of the cocaine occurred?
I waited in the car.
Who actually went in to get the drugs?
Landon.
Did Did he ask you for money to get it?
I can't remember. I don't know.
But how do you know he actually got the drugs from the house?
We were talking about buying some.
The cocaine, was that also used in the car?
Yes, sir.
And so from that location in Atlanta, well, at that location, do you know about what time it was?
I have no idea.
What time did you all meet at the gas station?
I believe it. I want to say it was like somewhere around maybe like 7, 8, maybe like 9, somewhere around there. It was later in the day.
So AM or PM?
PM,
So y'all met up about 7, 8, or 9?
somewhere around there. Yes, sir.
Okay. Then you drive to the location in Atlanta, did drugs, use them. Where do you go after that?
We just kept driving around.
There was no destination of any kind?
I don't believe so. I believe we were just driving around, just talking.
And can you describe your state as you're being driven around?
At the time I was just talking. I was hurt from what I had been through earlier in the day and just sorry.
Speak up for me, please.
I was just like my state of mind. I was hurt from what had happened earlier in the day. So we were just driving around talking.
When you say what had happened earlier in the day, this would have been with, is Jeremy?
Jermaine, I was just, yes, sir.
You were upset about what had happened between you and Jeremy.
Yes, sir. Jermaine, yes, sir.
Okay. So, how long did you all just drive around?
It had been a few hours. We drove from like the night before until early the next morning.
So when you say a few hours, how many hours?
I would say probably like around maybe like 7, 8 hours, 6 hours, somewhere around there.
Okay. Do you remember ever being driven onto Dogwood Road at all?
Yes, sir, I do.
Okay. Do you remember any incident occurring on that road?
I remember we were driving down that road, and at some point, me and him had leaned into each other, I believe, to kiss. And whenever that happened, I'm not exactly sure if I heard a noise or what got my attention, but something got my attention, and I had looked out my passenger window, and that's when I had seen that a mirror was missing off of the vehicle.
Okay. So before the mirror goes missing,
Mhm.
something got your attention, right?
Yes, sir.
Can you describe what it was that got your attention?
I believe I may have heard like a pop noise, but I'm not 100% sure on that. But I know something got my attention that made me look that direction.
Did that possible noise or action also get the defendant's attention?
I believe so.
Did he also observe, do you know if he's looking in the direction of where the mirror had come off as well?
Yes, because whenever I seen the mirror come off, he mentioned needing to go back around and find his mirror and put his mirror back on his vehicle.
So when you both saw the mirror was gone,
Yes, sir.
did the vehicle stop at any point?
No, sir.
So the defendant kept driving.
Yes, sir.
Okay. And then he told you that y'all had to return to get the mirror.
Yes, sir.
Okay. Was there any conversation about what caused the mirror to pop off?
Not at that time. There was like after he had mentioned the mirror like needing to be put back on the vehicle, we had looped back around somewhere and came back to that same road, to the same area. And that's whenever he had pulled over to the side of the road on that same side and got out of the vehicle. And he went looking for the mirror. So I got out after him and went looking, like I was behind him. So he was a good ways in front of me. And after he was like a ways in front of me, he turned around and he came back running and he was yelling, "Get back in the car, get back in the car." So I got back in the car and he got back in the driver's side and we started driving off. And then after we had drove off, that's when I heard sirens. And he said something about after that, he said something about he saw somebody laid out and they were moving.
Okay. So he said he saw that.
Yes, sir.
Okay. When you say you all looped around,
Mhm.
did you make a U-turn on that same road?
No, I don't believe so. I believe we turned, we went down another road somewhere. I don't know exactly what road, but we did like kind of like a big circle to come back to it.
Okay. So you basically rode down the same road in the same direction.
Yes, sir.
Okay. And when he pulled over, did he pull over to the right side or did he pull over to the left side?
The right side.
Okay. When you exited the vehicle,
Mhm.
about how far ahead was he already in front of you?
I would say about like 50 feet or so. He was a good little ways in front of me.
Okay. Could you see anything where he was other than where he was standing?
No, sir.
How would you describe the lighting in here?
It was dark. It was pretty dark.
Was there a pole light?
I don't remember seeing a light.
Okay. If you were looking at his feet from where he was standing, where you were standing, when you got out of the vehicle, could you tell what was at his feet?
I don't probably think I could even see his feet.
Okay. You mentioned he came running back to you. Can you describe his demeanor as he's running back to you?
He was pretty like frantic about it.
Okay. Pretty light.
Um,
You said he was pretty like,
frantic, like pretty, like something may have been wrong.
was this a change in his demeanor from when he got out of the car?
Yes, he was, because at first he was just looking for a mirror. And then when he came back running, it was like something was wrong.
Did you ask while he was running to the car what happened?
No, sir.
Did you feel it was suspicious that he was?
I
behaving this way?
thought it was weird,
That you
but
didn't
I didn't ask. No, sir.
When he told you to get in the car, you just complied.
Yes, sir.
In the past, whenever he's told you to do stuff, do you just like comply?
Yes, sir.
Let's talk about the conversation in the car as y'all are driving away.
Okay.
When he mentioned to you that he saw someone laying there, did he certainly say he saw the person moving?
He said he saw someone laid out. His words were laid out, and that they were moving. Yes, sir.
Okay. How did you react to that?
Honestly, at first I didn't really believe it. I thought he was exaggerating at first because we were drinking that night.
Okay. And did you ask him further questions?
No, sir.
Okay. Did you ever ask him to turn around and go back to the incident location?
I never asked to go back to that incident. No.
Did you feel concerned that he told you someone was laid out on the road?
Yes, I did feel concerned.
Did you feel the need to call the police?
I feel like we should have definitely called the police.
Said you heard sirens. Did you
Yes,
know
ma'am.
where that was coming from?
I believe at one point after we had already drove off, I've seen them coming towards that direction that we were coming from.
So the sirens are coming from the opposite direction.
Yeah, like they were coming towards us.
And did he make any statements further after saying what he saw?
I don't believe so.
So was the car just quiet?
I don't remember exactly what was talked about. It's been a long time.
Can you describe your emotions at that time?
I would say, like scared, worried.
And what were you scared and worried about?
Like I said, I thought I wasn't exactly sure that somebody was hit. I know he had mentioned that he saw somebody, but I was thinking at the time that, like, I was drunk. I was thinking that it was exaggeration.
You didn't see anything.
Yes, sir.
Where did you go after that?
I believe after that, I believe we went back down to Atlanta again. And then after going back down to Atlanta, we came back up to Roswell. And we went to the same road that the Jermaine lives on. We went to that same road, and there's like a church that's across from his house. We parked there's like a little driveway with a gate at the end that's behind the church. We parked in that little driveway. And
Oh, wait, I'm sorry.
okay.
Back up for me. So you said you went back down to Atlanta.
Yes, sir.
Why did you go back down to Atlanta?
I believe we picked up some more cocaine, I believe.
Was that the same location you all had been at earlier?
I believe so, but I'm not 100% sure.
Were you driving at that time?
No, sir.
You drive at any point?
No, sir. No, sir.
Who drove that whole night?
Landon drove the entire night.
When you left Atlanta, what day was it still?
I believe it was the next day. So I want to say Saturday.
At what time do you think the incident occurred when the vehicle was struck something or someone in the mirror?
I believe it was early morning, so maybe like 4 or 5 or somewhere around there.
Okay. So then you go back down to Atlanta.
Yes, sir.
From there, where do you go?
After we left Atlanta,
Yeah.
we came back up to Roswell.
Okay. Why did you come back up to Roswell?
He was buying weed from Jermaine.
Okay. So what date is it to you at this point?
Saturday, I think the 13th.
So you go, you get marijuana from Domain.
Yes, sir.
That's your ex-boyfriend, correct?
Yes, sir.
How does the defendant know Jermaine?
Jermaine lives like less than a mile from his mom's house.
Whose mom's house?
Landon's mom's house.
Did the defendant know about your recent breakup with?
Yes, sir. Yes, sir.
Did he often visit Jermaine for marijuana?
I believe he did in the past, but not like recently before that.
And after you get marijuana, where do you go?
We went after we did that. We went to a hotel in Norcross area.
Okay. Do you remember the name of this hotel?
It's something with like a 6 or 8 in it. I'm not exactly sure. I want to say like Motel 6 or something along those lines.
Okay. At the hotel, what happens?
I believe I went to sleep and I'm not exactly sure what he did.
Was he awake when you fell asleep?
I honestly don't remember. I believe so, but I don't remember for sure.
Can you describe your state at this point?
I don't remember exactly how I was thinking or feeling.
But yet use some of the marijuana as well that
Yeah, I was
had purchased?
high on weed and the cocaine and drunk from the alcohol. Yes, sir.
Okay. And who paid for the hotel?
Landon did. I believe.
Okay. In this hotel, had you been there before?
Yes, sir.
Why?
I had been there before. Whenever I was like in the relationship with him, I had been there with him like times throughout that.
And who is him?
Landon.
At that point at the hotel, Did y'all discuss anything regarding the incident on Dogwood Road?
I can't remember, but I'm not sure.
Did you, well, you did, you woke at some point.
Yes, sir.
Was he in the room?
I don't remember.
Was he absent at any time?
I'm not sure.
And when you woke up, at any point, if he was there, did you have any conversations about what happened on Dogwood Road?
I can't remember.
Even at that point, would you consider yourself sober after?
I was pretty much like gone from the drugs, like majority of the weekend.
Okay. Okay, so this lasted longer.
Yes, sir.
How long did you stay at the hotel?
I believe it was until like I think it was 2 days total, but I'm not 100% sure on that. But I believe it was.
Okay. So did you eat anything?
I don't think so.
So y'all didn't visit any restaurants?
I can't remember.
Is it typical when you're using drugs that you don't eat for long periods of time?
Yes, sir. Whenever I used to do coke, it would be like a while till I ate it. Sometimes like a whole day or a day and a half.
You say used to, are you still recreationally using?
No, I stopped June of this year.
And when you finally do leave the hotel,
Mhm.
where do you go?
After we finally left the hotel, we went back to that gas station to pick up my vehicle. And I got in my vehicle. He asked me to follow him. So we went to this parking lot that was at a different church in the Roswell area.
So before you left to go pick up your vehicle,
Mhm.
did y'all have any conversation about what you were about to do?
He told me what I was supposed to say to the police. He was going to be making an insurance claim on his vehicle. And
Okay, when you left the hotel and entered his vehicle before you went back to get yours,
mhm.
did you observe any damage to the car?
Yes, sir.
And what did you see?
I already knew that the mirror was missing, but I saw that again. And I saw the front of the vehicle had pretty bad damage to it.
And was anything else damaged other than the front?
I just believe the front and the mirror.
Did you get a chance to observe the bumper of the car?
No, sir. I don't believe so.
So you wouldn't know if any pieces of it were missing?
No, sir.
After you get in the car, you drive back to the gas station. And where's the gas station again?
I believe it was on exit 7. It was in Roswell. It's either a QT or a racetrack.
In exit 7, what highway is that on?
Highway 400.
When does the conversation happen where he tells you what to say to the police?
I believe it was in the parking lot that the report was made.
Drive to the parking lot.
Yes, sir.
Before you get there, though, does he tell you why that location is where you're going?
At some point, he mentioned that there was no cameras in that parking lot.
Have you ever been to that location before?
I've been there for like a funeral before, but not like in. I've never like parked my vehicle in that back area before.
But you've been to the church before?
Yeah, I've been there before.
Do you know if Landon had been to that back parking lot before?
I'm sure. I have no idea. I believe so.
He chose that location.
Yes, sir.
When you arrived, you were in your separate vehicles, right?
Yes, sir.
Right. So when does this conversation happen?
I believe it happened in the parking lot before the police were called.
So who gets out of what vehicle to join the other person?
He got out of his vehicle and got in the passenger side of my vehicle.
Where did he park his vehicle?
He was parked in one of the parking spots closer to the church. And then I parked like a few spots over from him.
And was there a car parked next to him when he parked his car?
There was a,
All right, bad question.
Okay.
Did he park next to an empty spot?
there was a couple of empty spots, and there was also a church, like smaller church bus in there.
And he gets into your car,
Yes, sir.
that conversation. Is that the point when he tells you what to say to the police?
Yes, I believe that's when he told me. He told me exactly what to say to the police, and then that's when he made the phone call to them.
What did he tell you to say?
He told me to say that I picked him up from that parking spot this morning, or that parking lot, and that nothing was wrong with his vehicle, and to tell them that me and him had spent the day with my parents, and that we had just got back to that parking lot, and that's when we saw the damage, and that somebody may have hit his vehicle,
Sorry.
and that's when we saw the damage, and somebody, like, he thought somebody hit and ran his vehicle.
Where do your parents live?
Incoming.
And when he told you this, did he tell you any, what times to say you dropped him off?
I think he said around 10 in the morning.
What time did he give you a time?
I'm sorry.
What was your answer?
I think he said to say that it was around 10 that morning.
Okay. And what time did he say to say you both returned to the apartment?
That we had just got back whenever he made the phone call to them.
You know about what time it was?
It was pretty late, like it was dark, so maybe like 9 or so. I'm not sure.
Did he tell you? Okay, so were you present for the 911 call that he made?
Yes, sir.
When he made that call, did the police ever respond?
Yes, sir, they came.
When they came, did you ever speak to them?
I waited in my car when he got out and spoke to them, and then an officer came over to my car and spoke to me about it. Yes, sir.
Was there a reason why you waited in your car?
I didn't want to speak to them.
Why?
I was scared.
What do you mean? What were you scared of?
I was scared to tell on him, and I was just scared in general. It was pretty like traumatic thing.
Why did you, when he told you what to say to the police, before we get to that, why did you agree to go along with the plan?
Because I didn't want to disagree with him.
Why?
Because I didn't.
You have to speak up louder. I don't understand this.
Someone's flipping a pen or something.
Okay, whoever's doing it, doesn't matter, but stop clicking the pen. Ms. Newborn is soft-spoken. This is a difficult topic right now, so no pen clicking. All right, pens down for the prosecutor.
I'm sorry, Mr. Warren. Why did you agree to go along with the plan?
Like I said, I didn't want to disagree with him. I didn't want to make him mad or have him get upset with me or anything.
Why? Has he gotten upset with you in the past?
Yes, sir.
And what has been your experience of what happens when
He gets physical. I've had like he's put his hands on me before. He's choked me before. He's hit my head into a mirror. I just didn't want to make him mad, and I didn't want to tell on him, especially in front of him.
in the past when he's been physical? Has there been any reason why?
There was the time that I was choked. We were watching TV at the same hotel, but it was like a whole different day. We were watching TV, and I can't remember exactly what we were watching, but I said something about what was on TV, and I don't know if I made a joke or if I said something and he took it wrong, but like he just like snapped and started choking me until I had a seizure.
What So what happened after you had a seizure?
I woke up, uh,
So what, do we need to explore this other situation that happened at another time? You know, I think you've highlighted why Ms. Newborn was reluctant to disagree with what she says was Mr. Christopher's plan in this case. So let's come back to this case.
So you were afraid to upset him in the parking lot.
yes, sir.
When the officer came over to your car and spoke to you, what did the officer say to you?
He asked me, like what, like exactly what I said, how we were at my parents' house and everything like that. But then towards the end, he said that he believed that the car was involved in an incident a few days prior to that.
And what did you say to him in response?
I told him that I didn't know that.
And
Can you hold on for 1 second? We just need to make sure folks have note cards. If there are a couple jurors who are wanting to get note cards. We're good?
so after you talked to the police,
Mhm.
you, after you talked to the police, did anyone get arrested that evening?
No, sir.
Did the defendant, did you leave that location?
Yes, sir.
And in whose vehicle did y'all leave in?
We left in my vehicle. They had taken his.
How did you know they had taken his vehicle?
They said that they were towing it, that they were taking it.
Did they tell you that, or did you learn that?
I think they told him that, and that whenever he got back in my car is whenever he mentioned that it was being taken.
Did he tell you why it was being taken?
No, I don't remember.
When you all left that location?
I drove him. His mom lived literally right down the street from there. We went towards his mom's house.
And what happened when you got to his mom's house?
I believe I was going to drop him off, but then later after that, we drove back to the incident. He had hidden a bag of weed at the incident, and we picked that bag back up, and then I dropped him back off at his mom's house.
When you say the incident, what do you mean the incident? You said he had hidden, I think you said a bag of weed at the incident where the hit and run happened, or at the church parking lot?
At the church parking lot.
And I'm sorry, did you just say that you dropped him off?
Yes, sir.
Okay. Where did you go?
I went home after I took him home.
Did you talk with him at any point after that?
We spoke here and there after that.
Did you ever learn of any new information regarding this case?
I found out it was like February, March of the next year. I got a call from him from a random number, and he was saying that his lawyer had recommended that he turn himself in, so that he had turned himself in and that he had just got out, and he told me to call his like actual cell phone number to help him find his number or find his phone, sorry.
Can he tell you what he did with his phone?
He said he hid it in bushes.
Say why?
No, sir.
At that point, what was your understanding of the criminal, what occurred at that time, were you, when he turned himself in, did you believe he was still being prosecuted?
I believed at the time that, like he said, he had turned himself in, so I thought that was like, it was over. I thought he turned himself in and admitted to it.
Moving forward, were you still worried about criminal prosecution of any kind?
I was worried that I could get in trouble for being there.
Were you still worried for him being prosecuted? You just thought it was over?
I believe I just thought it was over, and that's why I was so shocked whenever I got a call about a week ago.
We'll get to that.
Okay.
So I do want to take one moment and go back
Okay.
to the gas station.
Mm-hmm.
When you got in the car with Mr. Christopher,
Yes, sir.
did you see his phone anywhere?
He had his phone at first, and then throughout, like, I think he went in the store. Now that I'm talking about it, he went in the store, and then he came back out, and he couldn't find his phone. And then he had me look around. Like, actually, I tried to look around in his car to help him find it, and he got upset that I was opening his center console. And but eventually he did find it. Yes, sir.
And no, fast forward. You said you received a call about this case.
Yes, sir.
Okay. Which office contacted you, if any, or person?
The DA contacted me first, and then the public defenders tried to call, but I missed that call.
And when you got that call, what emotions and feelings did you have at that?
I was shocked just like shocked that it was still going on, and I was scared.
What were you scared
I didn't want to go through this.
Scared for yourself, or scared for?
I was scared for myself that one, I was gonna have to tell on somebody, and I didn't want to have to tell or anything like that.
Did you receive a subpoena in this case as well?
Yes, sir, I did.
Did you have any contact at that time with the defendant?
I had gotten some text messages from him.
Judge, I believe the state said exhibit
17 is
Judge.
the first you haven't marked. 15 and 16 were not tendered or admitted. So if we're going sequentially, let's do 17.
Judge, state's approaching the witness with what's marked as state said.
Okay.
This newborn, do you recognize the document?
Yes, sir.
Does it appear to be an accurate depiction of what it purports to be?
Yes, sir.
Does it appear to be altered in any way to your knowledge?
No, sir.
Judge, at this time, the state will request to tender into evidence and publish State's Exhibit 17.
Any objection to state 17?
Yeah.
It's admitted.
Ms. Newborn, what is in front of you?
It's text messages that I got from Landon after speaking to you guys.
Did you respond to that text message?
No, sir.
Can you tell the jury what that text message says?
The first one says, "Yo, what them folks talking about?" And then the next one says, "Say less." The next one is a screenshot of all the witnesses with their names and phone number and addresses. The next one says, "They told me you testifying on me. Damn, that's crazy." And the next one says, I guess I will see you at trial.
And are you on that witness list?
Yes, sir.
Do you have an address on that witness list?
Yes, sir.
Did you observe that at the time when you saw the text message?
Yes, sir.
Whose address is that?
It's an address I recently moved from. It's now my brother's address.
Your whose address?
My brother.
Brother.
What was your reaction to that text message?
It scared me seeing like my name and my address
Why?
because I don't know like what his intentions were. I didn't know maybe like he was wanting to do like pull up on my house or whatever. I didn't know.
And so at this point, if I'm hearing your testimony correct, well, what'd you do after this?
I told you guys that I got the screenshot.
I'm sorry, what'd you say?
What do you mean? What did I do?
After you got these text messages, what did you do?
I let you and the other DAs know that I had caught them.
And at that point, when you spoke to my office, did you decide to give the same account as what occurred 2 years ago, or did you decide to give a different account?
I decided to like tell you guys the truth, the full truth.
So, if I'm hearing you correctly, before you were scared for yourself
Yes, sir.
from being prosecuted, then you were afraid of the defendant after getting these text messages.
Yes, sir.
Then you decided to contact our office.
Yes, sir.
Tell the truth.
Yes, sir.
And when you contacted my office, what did you tell us?
I called you back and told you that I had some things I needed to talk to you about. And then that's when I came in.
Was that testimony now the testimony that you gave for the full defense today?
In the beginning, I left like a few things out.
And why'd you leave those in there?
Being scared, just I get nervous, especially like I don't know, I'm just nervous and scared.
And but everything you said here today about what actually occurred,
Is the truth. Yes, sir.
that's what you told our office.
Yes, sir.
Judge, I want the record to reflect that, and I have not shown this to opposing counsel, but it's in evidence, State's Exhibit 7, which is the body camera footage from Officer Lewis. The state would like to play timestamp 316 to 417 regarding the discourse with Ms. Newborn and Officer Lewis.
Okay, so already in evidence, and it does not encompass any of the segments that I've directed you to not play for the jury.
Yes.
Okay, you're free to publish that.
Hey there. So, how do you know him? Okay. And I mean, have you been with him all day?
I've been with him all day.
Okay. So when did he park his car here?
He parked here at 10:30.
Okay, were you with him when he parked it?
Yeah.
I'm sorry?
Yes. I was
Okay.
with him.
Was
I
it
picked him
damaged
up.
when he parked it?
No, no damage.
No damage at all?
No damage at all.
Okay, you got your ID on you? How long have you known him?
I've known him since I was like younger.
I'm sorry?
We met when we were little, like younger.
Okay, but how long have you known him recently?
What do you mean? I've known him
Have you
since I
known-
was like 14.
You've known him, see him weekly, monthly, all since you were little.
pretty much.
Okay.
I mean, it's been,
What do you mean?
like, I mean, I don't see him every day, but like,
Okay.
So Ms. Newborn, is that you in the video?
yes, sir.
Okay. And is that an accurate depiction of what occurred that night?
Yes, sir.
Okay. And so when you told officers that you dropped him off that morning, you're not telling the truth.
Correct.
Okay. And when you told officers that you didn't, sorry, I said dropped off, but you picked him up that morning, that wasn't the truth.
Correct. Yes.
Okay. But you had known him since 14.
Yes, sir.
Judge, one more clip, and this is the same body camera footage from Officer Lewis, but it's the second encounter with Ms. Newborn from 12:35 to 13:17, Exhibit 7.
This is the problem I have. That car was involved in a hit and run. It hit somebody, broke their leg.
I
They
don't
went out,
believe
they-
it was that car.
Yes, it is.
I don't believe that.
I do, because we have parts of that car in evidence right now.
I don't believe that because he's been with me all day.
Yeah, this happened Friday night.
Well, I know nothing about that.
Okay, when did he park the car here?
This morning.
You saw him park the car?
Yes.
You didn't see damage there, too? Okay, is that what you're going with?
Yes.
Okay, so I'll charge you with obstruction when I find out. Get
I
everything
didn't see any damage to any car.
going. You didn't see damage to his car?
Not until he put in the car.
Okay, that's fine. Have a seat.
So Ms. Newborn, in that interaction, when you denied knowing the car was a part of a hit and run, was that a lie as well?
Yes, it was a lie.
And at the time you knew it was not the truth,
Yes, sir.
but you chose to go along with the defendant's request.
Yes, sir.
And now you decided to tell the court the truth.
Yes, sir.
Can you tell the jury why?
I believe the victim deserves this, and I don't think what happened that night should be something that you just get away with.
And you've not been promised anything for your testimony today, correct?
No, sir, I haven't.
And you do know that you still may be prosecuted if possible.
Yes, sir.
Have you been told what to say to the jury today by anyone?
No, sir, I haven't. All I was told was just tell the truth.
I do want to ask you a question. After the defendant found his cell phone earlier at the gas station,
Mm-hmm.
can you say for sure whether that phone was in the car on Dogwood Road when the incident occurred?
I'm sure it was. I'm pretty sure.
And what is the defendant's cell phone number or last four digits?
8292.
Can you give us the whole, do you know the whole number?
Yes, sir.
What is that?
678-254-8292.
Okay. Did you and the defendant ever go to your parents' house that day? On December
No.
12th, with the day of the incident?
No, sir.
Okay, what about the next day on December 13th?
No, sir. He's never met my parents.
Okay. Did you tell anyone ever about this incident?
I told my cousin,
Your cousin's name?
Katie Newborn.
When did you tell her?
I'm sorry.
When did you tell her?
That same night.
When you say same night, the night that the hit and run happened, or the night that we just saw in the video where you were talking with the police?
The night the hit and run happened.
So before you were talking with the police?
Yes, sir.
Did you tell her the truth?
Yes, sir.
if I understand you correctly, you're giving your testimony today because simply just wanted to tell the truth.
Yes, sir.
No further questions.
Ms. Feely, before you go, I have a couple questions. We heard earlier, Ms. Newborn, a 911 call that Mr. Christopher made before the police showed up here. Were you with him when he made the call, as in sitting next to him, or was he out in that parking lot away from you?
He was in my car.
Okay. And when you arrived at the church parking lot that was in the video we just saw, was it already dark out or was it still daylight?
I believe it was still dark outside.
Okay. Ms. Feely?
We've never met before, right?
I don't believe so.
We've never spoken.
No, ma'am.
You've never spoken with Miss Wood,
No, ma'am.
but you've spoken to the prosecutor.
Yes.
You've spoken to him on the phone
Yes, ma'am.
and you met with him.
Yes, ma'am.
And they called you after almost 2 years about this case, right?
Yes, ma'am.
And so it was last week when you decided on the version of events that you testified to today?
Yes, ma'am.
And you were here earlier this week, right?
Yes, ma'am.
You testified under oath on Monday.
Yes, ma'am.
And on Monday, you testified that you were emotional wreck because of the breakup, right?
Yes, ma'am.
But you later bought weed from him that day of this incident, right?
I didn't buy it, but yes, we were there to buy weed.
You went to a location where he was.
Yes, I didn't get out of the car, interact with him.
And you testified about bringing the Jack Daniels bottle.
Yes, ma'am.
And about purchasing cocaine.
Yes.
And then you testified about then going to get more cocaine, right?
Yes.
And you testified also that you have been sober since June, right?
Yeah, it was like midsummer. Yes, ma'am.
You wouldn't want anything about this case to affect your life now.
Could you reword that?
You know that you could be arrested, right?
Yes, ma'am. I do know this.
Because what we saw in that video was you lying to the police.
Yes, ma'am.
And actually, I think the officer says we're going to charge her with obstruction.
Yes, ma'am.
And obstruction means knowingly and willfully obstructing a law enforcement officer.
Yes, ma'am.
So the state showed you a text message. You still have it?
Yes, I do.
Okay. If I may.
Mhm.
So again, the text says, yo, what them folks talking about, say less. They told me you testifying on me. Damn, that's crazy. I guess I will see you at trial.
Yes, ma'am.
And from that, you took that you were so afraid that he was going to roll up on you. Is that right?
I wasn't sure exactly what he would do. It was a lot going through my mind, but yes, ma'am.
Okay. And then that's when this version that you testified to came about that night.
I'm not sure exactly if I had spoke to the DA and told them before or after. Those messages came in within there were 2 days worth of messages.
And we're talking about last week.
Yes, ma'am.
And you testified about being very, very afraid and horrible things that Mr. Christopher has done. And you testified about that on Monday as well, right?
Yes, ma'am.
And you even said that he killed someone and put their body parts in the woods. Is that right?
He's told me that he's done that. Yes, ma'am.
Okay. But you had contact with him after this incident, right?
Yes, ma'am.
You texted with him.
Yes, ma'am.
You showed him pictures of your tattoo.
Mm-hmm.
Didn't lead anyone to believe before last week that you were afraid of him, right?
People know what I went through before with him, if that's what you're asking.
Okay. It is a lot of text messages, you're right, between you and him after the incident.
Okay.
Is that fair to say?
I can't remember, but I guess yes, ma'am.
Okay, so you do recall texting with him after the incident?
I talked to him like just randomly throughout that, yes, ma'am.
And sending him pictures of when you had a car accident?
I believe I did. Or whenever he had a car accident too. It may have been both, I'm not sure.
And
I've had an
sending,
accident since then.
okay, and sending pictures that show intimate parts?
Objection, Your Honor. State would request that if testimony be limited to relevance. She's already admitted that she's talked to him. The contents of those text messages are private and also just not relevant to today's trial.
What's the relevance of I think I understand the question you were about to ask. Tell me the relevance of that.
Someone wouldn't do that if they were feeling threatened or afraid of the person they're texting.
Okay,
They
as
would-
long as you keep the question generic, I'll allow it.
After the incident, at some point, you sent Mr. Christopher photos that show intimate body parts. Do you recall that?
Yes, ma'am.
Okay, thank you. And also on Monday, you testified, you hesitated, but then you testified that you have not made any definite deals with the state.
That's why I reiterated it, because when I'm talking, sometimes like what I say comes out a little bit off, or I just wanted to reiterate that at the end, which is why I said that I have not made any deals with them. They have just told me to come in and tell the truth.
They told you that they were going to charge you though, right?
No, they never said that they were going to charge me.
And you testified that you didn't want to tell on anyone.
Yes, ma'am.
But as soon as you got the text from Mr. Christopher, you immediately contacted the DA's office. Is that right?
Yes, ma'am.
And you also testified that you think that that Mr. Duffy, who was struck, deserves you coming in and testifying. Is that right?
He deserves this. Yes, ma'am.
And you didn't think that when you didn't call 911 that night, right?
I did think that. I was just scared.
And since December of 2020 to now, you have not been arrested for anything in connection with this case.
No, ma'am.
And to your knowledge, the police never got any cell phone records to show where your cell phone was at the time of this accident.
I have no idea.
And also on direct, you almost said that Mr. Christopher got on the passenger side after looking for the mirror.
Yeah, like I said, sometimes I have anxiety. I get where it's a little mixed up, but I was never in the driver's seat, and he was.
But there's no question that I can ask you right now, given your circumstances, that will get you to admit you were driving. Is that fair?
That I was what?
That you were driving?
I was never driving. No, ma'am.
So I think you're aware that Mr. Christopher, one of his charges was false report of a crime.
Yes, ma'am.
We see you on video more than once saying the same thing that he said. Is that right?
I believe so.
And while Mr. Christopher stands accused of false report of a crime, you have not had a warrant issued for false report of a crime to this day. Is that fair?
I haven't, no, ma'am.
Even though there's ample video evidence of you saying the same thing that Mr. Christopher said.
Yes, ma'am.
Thank you.
Thank you. As in you're done?
Yes.
Okay,
Sorry.
that's all right. I didn't want to cut you short. Mr. Hand,
This newborn,
hold on one second. Is that S17?
it is, Judge.
Okay, you can stay there as long as ultimately it works its way to Ms. Rivers.
Yes, Judge. And actually, I'd like to see her.
Sure.
This newborn, you mentioned that one of the messages you received from the defendant at first said less.
Yes, sir.
What did you take that to mean?
Like, I wasn't sure if he was saying say less because I wasn't responding or if he was trying to keep me quiet
You said, keep me quiet.
from telling what really happened.
And because you knew what actually happened.
Yes, sir.
Your relationship with the defendant, how would you characterize it as far as, was it on and off again?
It was on and off. It was, yeah, it was like toxic, you could say, but it was on and off.
So does that mean there are times where you were, what is on and off?
Like everything would be okay, and we'd like he always said it wasn't a relationship, but I consider it was. And then like maybe like he'll get mad or we'll get mad at each other and just stop talking for a little while and then come back and talk again and then stop. It was just on and off like that.
So the periods where you were okay with him,
Mhm.
periods where the relationship.
Yes, sir.
When you learned the defendant had turned himself in
Mhm.
earlier in 2021, you said February or March.
Yes, sir.
Had y'all been talking during that period?
We had talked like earlier that year, I believe, but not that like not when I got that call.
At that time, were things okay between you and him?
Yeah, I believe so.
When things are okay, you feel comfortable communicating.
Yes, sir.
Referring to moving forward to when you were receiving these text messages.
Mhm.
Would you characterize this as a time when you were afraid?
I wasn't afraid. I haven't had any interaction since then, but I wasn't afraid until I got the screenshot.
Okay, I'm sorry, I said the question wrong. When you got that screenshot, would you consider yourself afraid?
Yes, sir.
That time?
Yes, sir.
But previously not.
Right.
And while you were afraid, did you respond?
No, sir.
Communicate at all with him after you received those sentences?
No, sir.
I do want to ask you one more question about the cell phone.
Okay.
You mentioned that you knew it was in the car, that you had it.
Yes, sir.
Did you see it physically in the car?
I remember him like saying he found it in his vehicle.
Did you actually see the phone?
I saw it before he had lost it in the vehicle, and then like I said, then he said he found it, and I don't want to say anything that I don't remember exactly, but I believe he was using the phone, like calling, like he had to call to pick up the weed and all that. So.
Judge, the state would like to retrieve State's Exhibit 12.
It's a photo?
Yes, it is, Judge.
Okay.
It's two different ones. Judgments. Talking in my skills of items is not the best, sorry.
You do have that trial partner there who could help you with it while you're asking questions.
True judge. Not sure Mr. Malcolm is any better than I am, Judge. Sorry. This newborn, 6 Exhibit 12, do you see what that is?
Yes, sir.
What is it?
It's a picture of the front of his vehicle with the damage.
Do you recognize that vehicle?
Yes, sir.
What vehicle is that?
That's the Toyota Highlander, Landon's car.
Okay, and do you see damage to the vehicle in that photo?
Yes, sir, I do.
Was that the damage that you saw the next day when you observed the car?
Yes, sir, it's the damage I saw after.
That an accurate depiction of all the damage that was caused from the hit and run?
I believe so, yes, sir.
And no further questions, Judge.
Any recross?
So your testimony puts you in the Toyota Highlander at the time Mr. Duffy was struck, right?
Yes, ma'am.
And you were drunk and high.
Yes, ma'am.
And you also know that perjury is a crime in Georgia.
Yes, ma'am.
Thank you.
All right, jurors, if you have questions for Ms. Newborn, pass them forward to Deputy Gordon, please. Thank you, sir.
Second. Ms. Newborn. Let me get these organized. Okay. Can you tell the jurors why it was that you didn't provide this version of events about what happened from the very beginning? In other words, why you told the police something different from what you've told the jurors today?
Back then I was.
And make sure you're talking into the microphone.
I told the police something different because I didn't want to tell on Landon. Landon was in the same parking lot whenever I was talking to the police.
Okay. And you didn't want to tell on him because you cared about him, you were afraid of him, both, neither? Why was it that you didn't want to tell on Mr. Christopher?
I didn't want to make him mad.
Okay. Is any part of your testimony today and the version of events you're sharing with the jury today some form of retaliation against Mr. Christopher for things you've said he did to you?
No, sir, not at all.
Are you worried at all that Mr. Christopher is somehow going to retaliate against you for giving this version of events to the jury today?
I feel like maybe after all this is over, I feel like, yeah. Yes, sir.
Okay. Did you and Mr. Christopher, up until you got the texts that are in state 17, were you maintaining any form of relationship, or had you and he not been talking, texting, calling for a number of months?
It had been like a few months. Like I said, it was here and there, like the text messages that were talked about earlier, but Like I hadn't seen him or anything.
Okay, seen as in like been physically in the same space with him.
Yeah, like person to person.
Okay, that had not happened for how long until today? You guys are in the same room now?
It's been months.
Months?
Yes, sir.
Okay. Was there a particular reason why you and Mr. Christopher stopped spending time together?
It just kind of like cut off around that time frame. He said that his lawyer recommended him not to talk to me anymore.
Okay. And when you say that time frame, what time frame are you talking about?
Whenever I think it was like a little bit after the incident, or whenever I got the phone call of him turning himself in.
Okay. The phone that Mr. Christopher had with him the night of the hit and run, the accident, was that the phone you've normally seen him with?
He's had multiple phones throughout the years, so I'm not sure.
Okay. The night of the incident where the mirror got knocked off the car, were you, so basically from the time you went to that gas station and got into the Highlander with Mr. Christopher, and then you've told the jury about different places you all went, were you using your phone that night?
I had my phone on me.
Okay.
I believe, I'm not 100% sure, but I believe he had told me to turn my phone off at some point during that weekend. I'm not sure when during the weekend, but I did have my phone on me.
Okay. Do you remember if Mr. Christopher was using his phone, not over the whole weekend, but in particular, that point in time when you were driving back from Atlanta and just before there was that situation where you two were leaning in and then there's the bump?
I believe so, yes.
He was using it?
Yes, sir, I believe so.
Okay. All right. Mr. Hand, do you have any questions you want to ask based on that?
Yes, Judge, I do. Ms. Newborn, you stated that you were told at some point to turn your phone off.
Yes, sir.
Who were you told to do that by?
Landon.
Okay, why did he tell you to do that?
He didn't say. He just told me to turn my phone off, and like that wasn't exactly out of the normal because he's done that before, but
Okay. So when you say it's not out of the normal, you didn't think it was related to this? the
I
subject of
didn't,
this?
no, sir, I didn't know.
Okay. When you, after this hit and run incident,
Mhm.
morning of December 12th, you mentioned that you spoke to your cousin.
Yes, sir.
Was that in person, by phone?
I called her that same night on the
Okay,
phone.
the same night?
Yeah, like night, early morning. Yeah.
It was dark out.
Yes, sir.
Okay.
And about what time was it? Do you know?
It was like not that long after the incident happened.
Okay. And did you tell her the full story, parts of the story?
I told her the full story.
Okay. And did you ever talk to her again about the event?
After the event, she used to live in Alabama. I went to her house in Alabama, and I believe I like just told her again in Alabama, like in person.
Nothing further to it.
Ms. Feely.
You just mentioned that you knew Mr. Christopher to have multiple phones,
Yes, ma'am.
but that was because you've known him for a long time, right?
Yes, ma'am.
And he only has one phone with one number at a time, right?
I believe so.
Because you mentioned that he did call you from another number one time, but it was to find his phone.
Yes, it was a different phone number.
Okay, so he called you from a different phone number because he wanted you to call his phone number to find his phone.
Yes, ma'am.
Thank you.
That
You can explain your answer.
okay. That was after he had turned himself in. He said he had hid his phone in bushes and he needed to find it after that.
He didn't have more than one phone the night of the incident, right?
I don't believe so.
All right. Anything else?
Briefly, Judge?
Sure.
Ms. Newborn,
Yes,
that morning, December 12th in the 8th. Oh, let me start over. When you're at the gas station with Mr. Christopher, defendant, you saw that he told you he found his phone.
Yes, sir.
Were you certain that that was the phone that you have his phone number for?
I'm certain. Yes, sir.
Okay, and that's because you know what that phone looks like?
I don't know what that phone looks like, but I called him to meet him there, and that's the phone he had on him. He only had one phone that night.
So when you called him, was he at the location when you called to meet him there?
No, he was, I don't know where he was. He met me there.
So you don't know for sure if he came to the location with the same phone that you called?
No, I don't know for sure.
Okay, thank you. Nothing further.
All right, Ms. Newborn, thank you for your time. You are free to go. You can leave that piece of paper right there, okay? Ladies and gentlemen, we're going to have a choppy schedule over the next few hours. I want to give you your morning break. It's a little bit later, but I didn't want to interrupt the back and forth with the lawyers and Ms. Newborn. So I want to make it a short break because we are going to break for lunch, more like 11:35 or 11:40. And it will be a slightly longer lunch just because of scheduling issues. And we're going to get back around 1:15. The state has only 2 more witnesses. We're going to start one of those witnesses now after your short break, just restroom. And we'll get through as much of that as we can. And then we'll break for lunch. And then there is a final witness as currently represented. Things can always change. That won't take all that long, but we won't pick up till 1:15, 1:30-ish. And then it's expected that the state will rest. We'll see if the defense is putting up any evidence, no burden to do so. So it could be that both sides rest early, mid-afternoon. And then I'll probably send you home for the day because then the lawyers and I have to have a long conference about the law that they want me to give you when I charge you. Which would mean tomorrow morning, we would start with closing arguments, then I charge you, and you get the case mid-morning to begin your deliberations. Maybe that we decide to do the closings later today so that you go home with the closings, but we have to have this charge conference first. So that's just a preview of things to come. Take a quick break. I'm gonna have Deputy Gordon get you sooner than usual. If that's not enough time, push back, and we'll get going. Don't talk about the case, no outside research. Mr. Shelton, can you hold on 1 second?
Yes, sir.
Just want to make sure, same schedule, has anything changed?
So I told him, I said, make sure I get back in because I'm 1 o'clock. So,
You're gonna be back by 1?
I mean, because I'm gonna leave here probably like 11:35.
Yeah.
Probably take about 25 minutes to get there.
Right,
Probably get them about 25 minutes.
okay. If you can be,
Get back home. I mean, 'cause I just don't want to chance it.
no, I understand. I wanted to maximize your time at the services, so I was gonna have everyone be back here by 1:15. So you should aim for 1 because it may be a little bit later, but if you could aim to be back here by 1:15 at the latest, that would be great.
I got you.
Okay, go. Mr. Hand, anything from the state?
No, Judge.
Ms. Wood, anything from the defense?
No, Your
All right, 5 minutes, but we'll have a long lunch break coming soon.
Give me some of those cards. I have time, these index cards. Give them to us before they sit, because it was a lot of sofa mats, chairs, chains, And when I have businesses like this, I can't hear.
Some good case law. I'll send you some good case law on the jury charge.
Oh, yeah, it doesn't apply.
I know. Okay, I was just making sure that those two cases, I got it
I
straight.
couldn't open the first one.
It's in the subject line. Like you can see it in the body or the subject line.
It's only the second one.
See,
Oh, okay.
that's the one Dunaway wrote it out on.
Yeah, yeah. He's not gonna give that. There's no.
Thank you.
What kind of water, man, is it?
Can you see if they are able to head on in?
Everyone's good to go?
Great. Let me make sure we're good. I missed, oh, we're not quite ready. Lots of moving parts.
We're ready to, oh, were you looking at me?
I wasn't.
Oh.
I did, but then I paused because
Oh.
I realized
It's the most
that,
important person.
exactly. All right, Mr. Hand, anything from the state before we bring the jurors in?
No.
Okay, and the other Ms. Newborn is available?
Yes.
Great. Ms. Wood, anything from the defense?
No, Your Honor.
Okay, let's bring the jurors in, please.
All right, so jurors.
Thank you, Deputy Gordon. Welcome back, ladies and gentlemen. Mr. Hand, if you would call your next witness, please.
Yes, Judge, actually, Judge, before.
Hold on one second. Sorry. Yes?
Before I proceed, I would like to, I don't believe I ever tendered exhibits, states 15 and 16 into evidence.
You did not. Those are the warrants. I don't remember who worked with Officer Ramuno from the defense. Okay. Is there any objection to the admission of states 15 and 16?
Did we lay the foundation and authenticated yesterday?
Well, I guess that's, I'm not sure who you're asking. I recall the exhibits and the exchange that Mr. Hand had with Officer Ramuno, so I'm happy to respond to an objection if that's your objection.
It is at this time, Your Honor.
Okay, I find that there was a sufficient foundation laid and that they were authenticated by Officer Ramuno. So I'll admit them as part of the record. Whether they go out with the jury or not is something we'll talk about at the appropriate time.
Understood, Judge. Thank you.
Sure.
Judge, at this time, the state will call Ms. Katie Newborn.
Katie Newborn.
Before we sit here, raise your right hand. You swear affirm that the testimony you will give the truth, the whole truth, and nothing but the truth alone. Fill in and I'll see. State the spelling of your name for the record.
My name is Katie Newborn,
Please spell it for the record.
KATIENEWBORN.
Ms. Newborn, you are soft-spoken, which is fine, but that just means you need to move a little closer to that microphone. The chair doesn't have wheels, so you really have to heft it and then just lean on into the microphone.
Yeah, so it'll be okay.
Okay, great. Thank you.
Ms. Katie Newborn, can you tell the court if you're currently working and where you live?
I'm currently working. I work at Piedmont Tractor and Equipment, and I live in Oakwood, Georgia, Hall County.
Where's Oakwood?
Hall County.
Hall County.
And how do you know, Kayla Newborn?
I do. She is family. She is my cousin.
And how, your family, but have you known each other all your lives?
Most of our lives, yes, all of it.
Did you grow up together?
We did not grow up together. We had on and offs with family meetings.
How long recently would you all communicate often with one another?
We started communicating back in 2020 around Thanksgiving time.
Okay, was there a reason for that? Just a holiday?
No, we decided we wanted to start getting back together as family and started doing things together.
At that time, around that Thanksgiving time, were y'all living in the same state?
No,
Where were you living?
I was living in Alabama,
Okay, and where was she living?
Georgia.
And so is it fair to say it was a long distance family relationship?
Yes.
And after that, how often did you and her talk?
We talked daily for a while up until about April of this year, June, April, I want to say specifically.
And were these conversations that were close, intimate conversations, or were they kind of surface level?
Sporadic conversations here and there.
Were they about family?
Family, us going to do things to hang out together.
Did y'all ever hang out together?
A lot,
Okay.
a lot.
Would you come to Georgia?
She would come to me because I did not have a vehicle at the time.
Did she have a vehicle?
She did at the time, yes.
What type of vehicle?
The first vehicle that she had that I know of was the Kia. It was white. I don't remember exactly what kind of vehicle. I just know it was a Kia.
Was that around December 2020 that she had one?
Yes.
And how would you describe your relationship around that time with your cousin?
It was pretty good. We decided to get back together. We clicked. Things kind of were smooth.
And would you consider yourself someone she would confide in?
At the time, yes.
Did she talk to you about people she was dating?
On and off, yes.
Talk to you about where she worked?
Yes.
Did she talk to you about other friends that she had?
A few of them, not all of them.
Would you say that she felt comfortable sharing close details, private details?
Some things, a lot of things, mostly, yes.
So did you share similar things back with her?
Oh, I did. I did.
Do you consider that y'all were close around that time?
At that time, yes.
Do you remember her giving you a call in early December, about December 12th of 2020?
I do.
What time do you recall?
I don't exactly know what time. I know she waited until later in the afternoon to call me.
And when you got a phone call from her, what was that call about?
It's something she wanted to talk to me about in person. Something had happened and she wanted to tell me about it to get opinion on it and see if she could come over to my house to talk to me about it in person.
And did she share some of the details with you?
Not until she got to my house, not over the phone.
So you're saying by phone, she didn't share anything?
She didn't share much with me other than she just had something to talk to me about that she wasn't supposed to tell anybody about.
Did she say that incident involved anybody?
Not until she got to my house, no.
Where were you living at the time?
Alabama.
And at the time she was here in Georgia.
Mm-hmm.
And she left. Did she eventually come to you?
She did.
She left the state of Georgia to come to you.
Yes.
What city were you living in?
I was living in Fife, Alabama.
How far away is that from you?
From Atlanta, I want to say about 2.5, 3 hours, depending on traffic.
And so not far, but a drive, right?
Yes.
And when did she come and visit you?
That next morning,
You know what date?
the 13th,
Sure, or is that just like an estimate?
an estimated date, but I'm sure it was the next day because she called me, said, I got to come see you. She had to take care of a few things. She didn't say what. And then she came over the next day.
Okay. And she drives to Alabama,
Mhm.
pulls up to your residence up here. I see. And what type of car did she have?
A white Kia.
And what did you observe were you home when she arrived?
Mhm.
Okay. What did you observe when she got there?
She was shaky, nervous, a bit scared. Her face and demeanor just said it all. Like, so I asked her what was going on.
When you say said it all, what do you?
Something had happened and it was deeply concerning.
Had you seen her in that state before?
A few times, but not very many.
And what she told?
And she had told me that she was possibly involved with an incident of possibly a hit and run. She didn't say exactly what kind. It might have been a deer, it might have been a person, but she was told not to tell me. And then she found out what had happened. And she had told me that it was a person instead of a deer, like originally thought.
And well, you stated she was told not to tell.
She was told not to tell anyone.
By whom?
A guy named Landon.
Okay. Have you ever met Landon?
I have not met him.
Have you ever seen Landon?
I've seen pictures of him, but never met him in person.
How do you know there were pictures of Landon?
She would show me his name and everything on them as well, like through Facebook.
Is there, from those pictures you remember, is that person in this courtroom?
Sitting over there.
Can you describe something he's wearing?
Gray shirt. Kind of like a pullover hoodie.
A bit more. They're cheaper.
I can't see from right here. Is it okay if I stand?
Yeah.
He was a bit bigger then, had a bigger build.
Well, clothing wise.
Clothing wise?
Yeah. Something other than gray shirt.
In this picture, he was wearing a black shirt.
No, he's trying
Oh, and
to identify him today.
Yeah.
beard.
Okay. So
Beard.
guy with the beard.
Yes. Sorry.
No, you're doing fine.
I believe that would suffice to identify.
It would. I find that Katie Newborn has identified Mr. Christopher.
So she was told by Landon for a conversation with you, not to say anything.
Yes.
She said why she didn't say anything.
Because it could get him in trouble. It could also get her in trouble as well, but more him because of him driving.
Did she tell you what happened that night?
They were both drinking and doing drugs,
What type of drug?
cocaine,
Did she say what they were drinking?
Jack Daniels
She say where she got the Jack Daniels from?
from Mr. Landon and where she had it herself.
Does that mean?
He would buy some, she had some.
Okay. Well, sorry. Are you saying you don't know where she got it from, or? The
She-
question was
she
whether
had-
who was
Hold
drinking?
on one
Both of them
second.
were drinking.
You guys are talking over each other, and that makes it really hard for the court reporter. So, Mr. Hand, you need to wait until Ms. Newborn's done. And similarly, you may know where the question is going, but you can't buzz in early. Gotta wait till you hear the whole question and then give it an answer so that court reporter got it.
Do you know where she got the Jack Daniels from?
She had bought some and Landon had bought some, so they both were drinking together. But more of, he bought more while they were driving around and stuff, from what I understand.
Did she tell you who bought the drugs?
Landon.
Tell you where the drugs were bought?
No, she did not. Just that he would get them.
Did she state who was driving that night?
Landon,
Did she tell you whether she drove at any point that evening?
and she did not.
Did she tell you what type of car they were in at the time?
It was like a red Explorer.
That what she said?
Yes,
So when she told you what occurred that evening, that morning, did she tell you if she called the police or anything?
she did not call the police or anything like that. She was busy being rushed to get back into the vehicle after they heard sirens.
And did she tell you if she saw anything while she was outside the vehicle?
She possibly thought it was a person, but being rushed, she could not specifically tell.
Did she tell you whether Mr. Christopher saw anything within?
He did not, that I know of. They both thought of something, but they didn't know if it was actually person or not.
This is what she told you?
Yes.
Did she tell you about the fears that she had as a result of this situation?
That he might try hurting her if she was to tell somebody due to a past with them.
Did she tell you that she wanted to tell the truth?
She did, but was scared too, of course, because of Landon and how their past was and what he's done to her before.
Did she tell you that she spoke to the police at any point?
She told me that they were asking questions, that they had asked questions when they were doing an investigation about the vehicle, about where it was that night, things like that. Other than that, not really anything else.
Did she tell you that she made a statement to the police about what occurred?
She told me that she had made a statement about an insurance thing that had happened. So that way the vehicle was covered somewhere else for that night. But that was because he had asked her to.
He being who?
Landon.
So was it your understanding that she did not tell the truth about what occurred to the police?
Correct. At that time, yes, correct.
Why?
Because my cousin Kayla, did not want to get in trouble, but she knew the consequences, but was also told that if she told the truth, that things could happen as well. By Landon.
When she came to your house and she was frightened, did you do anything to calm her down? Or?
I tried getting her mind off of it by taking her out to eat, trying to, just watch movies, sit and talk, listen to music, other than actually what she was going through.
And when did she leave your home?
The next day, because she had to go to work.
You know where she was working at the time?
At the time, Mary Maids.
Did she ever tell you why they thought it was a person?
The way that it sounded on the vehicle, it could have either been a deer or a person, but there was also she noticed a noise, a moan of some sort before getting back in the vehicle. But again, being rushed, she couldn't be specific on it, but she did think that it was a person.
She said that she herself heard the moan.
She did.
Did she state that the defendant heard the moaning as well?
She did not.
So how did she tell you that she thought the defendant, or did she tell you that the defendant thought it was a person at all?
She did not know. They thought it was a deer and or a person, one of the two, but he did not specify to her specifically.
All right. Ms. Feely? And we're about out of time, so I'm not, if you're going to be short, great. If you're not, we should stop.
Sure.
Great.
Ms. Newborn, you testified that Kayla Newborn called you to set up an in-person meeting about this.
Yes,
And because she didn't want to share it over the phone,
correct,
she didn't want there to be text messages out there.
correct,
So she left the state and drove 2.5 to 3 hours to meet with you in person.
correct,
And she was shaky and nervous.
correct.
And she told you that she found out it was a person that was hit after that night.
Afterwards, yes.
So not the day of.
Mm-mm.
Okay, because the day of, they thought it was a deer.
Yes.
Right. And she knew she was more worried for Mr. Christopher than herself because she knew the driver would be in more trouble.
No,
Okay. She was worried then.
she was worried about both of them, but more or less what he would do to her afterwards.
Okay. So she didn't know that the driver would be in more trouble than a passenger.
Well, she figured as much.
Yeah. Thanks. Nothing further.
Mr. Hand, anything else for Katie Newborn?
To Judge.
Just ask.
I know you mentioned it. Ms. Newborn, when your cousin came to you from Georgia, now in Alabama, and talked to you about this situation, did you believe her?
I did.
Why?
The way that she was going on about it and then how she had called me when she left. I started looking into it, and before I could find the answers, she told me about it and then told me how I could go about looking into it. And I pulled it up and found out about it, correct?
What do you mean by looking into it?
I went through Google and I searched up what she had told me that she had found out through the news, and I pulled it up.
It was a news article.
Yes.
Nothing further, Judge.
Okay. Ms. Feely, anything else? Any questions from the jurors? Thank you. Counsel, if you just come right over here. Find out. I'm using your first name as well, just so the record is clear which newborn we're talking to. So Katie Newborn. Why was it that your relationship with your cousin cooled off or ended in April of this year?
Pardon my language, but I'm an asshole.
Okay. So you guys had some disagreement. You're taking responsibility for it.
Yeah.
But that's why. Okay. Got it. Your word, not mine.
Exactly.
You mentioned that your cousin told you she had been using drugs the night of this incident she told you about with
Correct.
Mr. Christopher. Is that something you had known her to do before or after as well? In other words, were you aware that she used drugs, or was this never heard
That
about?
was news to me.
Okay. And did your cousin ever tell you what she meant when she said things could happen to her if she talked to the police about what happened?
She was afraid that Landon would put his hands on her again.
Okay. She had told you that in the past had
What
been
had
an
happened with her, yes.
aspect of their relationship.
Yes.
Okay. Mr. Hand, do you have any follow-up questions? Ms. Feely?
Yeah.
All right. Ms. Newborn, I appreciate you coming all the way down here. You are free to go.
Thank you.
You're very welcome. So, ladies and gentlemen, we're going to break for lunch. It's going to be a slightly longer lunch. I'd ask you all to be back by 1:15. We'll try to get started between 1:15 and 1:30. But if you can be here by 1:15, we'll get going as soon as possible. I'll be here. And we'll figure out what we can do. Don't talk about the case during lunch, no outside research. And if you didn't like where you ate yesterday, eat in a different place today. Deputy Gordon will give you advice other than, what's it called? American Deli? All right. Thank you for your attention, and we'll see you back between 1:15 and 1:30. Mr. Hand, anything else before we break? You believe you can have your last witness here by 1:15? Great. Ms. Wood, anything else before we break?
No, Your Honor.
When we come back, I want to have the conversation with you, Mr. Christopher, about whether you're going to testify or not. So enjoy lunch, but just know that before the jury comes out, assuming I remember, I'll have that exchange with you. Your lawyers will be here, the jurors won't, about whether you're going to testify, okay? All right, thank you.
Yes.
Oh, yeah.
Ms. Rivers, you ready? All right, we are back on the record in State versus Christopher. It's 1:20. We've got our prosecutors here, our defense attorneys, plus a secret supervisor in the back, and Mr. Christopher is here. I need to have a conversation with Mr. Christopher about his decision to testify, but before I do that, anything I need to know from the state side?
Yes, Judge.
And what's that?
Judge, the state would request, I know so far we've represented only that Ms. Hooper will be our last witness. We will renew our request for Sergeant Fortunato to appear via Zoom if possible.
Okay. Is Ms. Hooper in the vicinity?
She's right outside, Judge.
Excellent. Smiling?
Oh, now.
Okay. So Ms. Hooper is here, and then you'd also like to get testimony from Sergeant Fortunato, but that would, for whatever reason, need to be, what is the reason? Why can Sergeant Fortunato, if he's still on the Roswell Police Force, not be here when Officer Bath managed to be here twice?
Judge, Sergeant Fortunato and his wife and kids are all sick with the flu.
Okay.
And so he didn't want to come into court and possibly spread that.
Expose others to what he is dealing with his family. Okay. And just to summarize, is Sergeant Fortunato the close-shaven gentleman who we have on camera who was interacting with Mr. Christopher, not on there was no Mr. Christopher the first night, the night of the 13th, when Mr. Christopher made the 911 call about his car having been hit?
Yes, Judge.
Okay.
Sergeant Fortunato, however, did respond to both scenes.
Okay, so he was at both, but in particular, if I'm trying to recognize the guy,
From the call.
he's the one with whom Mr. Christopher had the exchange about bad apples.
Yes.
Okay, got it. And what would he be adding to the mix?
Judge, he would be identifying the physical evidence in the case that was recovered and showing how it matched the vehicle that he saw when he responded to the second incident.
Okay, any reason you didn't have Ramuno do that as the kind of lead traffic guy?
Judge, Detective Ramuno, although he knew that they matched, he himself did not do the matching.
So well, the matching was done by this expert we had who, for whatever reason, wasn't shown the piece of the car that he examined. There's a picture of it.
Right. And at the time, we didn't have the physical items.
Okay, but now we have the physical items.
Yes.
Does that include the side view mirror?
Yes.
Does the side view mirror have a serial number in it that matches the serial number of the SUV of the Highlander?
From the report. However, Sergeant Fortunato will say that he is not the one who ran the serial number to discover that it matched, but it's not an exact match, it's just a range of
Meaning this
2001 to 2006 Highlanders.
Got it. It didn't come from a Honda. It didn't come from a Volkswagen. It came from a Highlander. We can look at the color of the paint, but it's not an actual VIN match. It had to have come from that car.
Yes.
Got it. And Ramuno wasn't in a position to talk about that.
Ramuno could not talk about that with the physical evidence because we didn't have it.
Okay, understood. All right, that helps put Sergeant Fortunato in context, in particular, his reluctance to get juror sick. Ms. Wood, you made clear earlier today that it wasn't necessarily a yes to Fortunato, and that I shouldn't take Mr. Hand's representation that you had always been on board with Fortunato appearing virtually. But now it presents itself again. What is the defense perspective on that?
We object to testifying virtually.
Okay, all right. And in a moment, you prefer a continuance if that's what I decide we ought to do.
You asked him to exclude the witness. Cumulative of what's already been said is he's been on the body cam.
Well, the bit about the match in the parts wouldn't be cumulative. Maybe that can be stipulated too. I don't know what the defense wants to do, but I just want to think through the options. I'm going to hear from Mr. Abate before I lay out all the options. But I know one of them is, well, I guess we could just wait and not make everyone sit here, but delay the proceedings so that we reach a point where Sergeant Fortunato is comfortable to come down here. I agree with you. If it was simply for him to look at the video and say, that's me, and I didn't think that Mr. Christopher was being real upfront about what was going on, that advances things very little. But the getting the mirror and the little rhombus shaped piece of plastic in, that wouldn't be cumulative.
And that part is the part that we want to confront him in court about.
Okay. All right. Mr. Abate?
Judge, we can have Sergeant Fortunato here in 40 minutes. The reason, so his wife and kids have been sick all week. He returned to work today. The reason we, I guess, broached the topic of Zoom was we didn't want to hold up the court proceedings, but I can get him en route here. Ms. Hooper, I know won't take 40 minutes, so it may be a short delay before he can testify in person. We prefer in person. We were just trying to avoid any sort of delay to the court or to counsel.
Okay. Well, based on the defense concerns, we should have Sergeant Fortunato blue lighting his way down here. And if we need to pause, we'll do that. Maybe we can start our charge conference while we're waiting. But the state's going to rest today, it sounds like, no matter what. And so I don't think we're delaying things for the jury too much. Okay. Thank you. All right. But we are ready for Ms. Hooper after Mr. Christopher and I have our conversation.
Yes, sir.
All right. Any other witnesses you might have fall out of the sky today?
No, sir.
Okay. All right. Mr. Christopher, do you understand that you have a right to testify and that if you want to testify in this case, no one can prevent you from doing so? Your lawyers may be telling you, and you don't need to tell me what they're telling you, they may be telling you that's the worst idea in the world. They don't have a veto. In the end, if you want to testify, that's your decision. You understand? Okay. Do you understand that in the same way, but in the opposite direction, no one can force you to testify, meaning you have an absolute right to remain silent if that's what you want to do. You understand? In other words, you get to decide, testify, not testify. And you understand that in a moment, I'll be asking you and not Ms. Feely or Ms. Wood or Ms. Primovic whether Landon Christopher wants to testify. You understand that? You're welcome to listen to and follow the advice of your lawyers, but it's not their decision, it's yours. Okay? Do you understand that if you choose not to testify, I will be telling the jury, one of my legal instructions to the jury will be that they are to draw no inferences or conclusions or anything like that from your decision. Do you understand that if you choose to testify, not only do you answer questions from your lawyers, which are generally the easier ones, they say what happened next, and they're designed to put things in as good a light as possible for you, but you'll also have to answer all legally proper questions from the prosecutor. You understand that? You don't get to take the fifth on the stand. If you choose to testify, you open yourself up to that cross-examination where you don't get to say, well, I'm not answering that question. Understand? Okay. Understanding those things, and I hear you, and I believe you do understand them. Mr. Christopher, do you want to testify in your case? All right. I find that Mr. Christopher has made a decision not to testify with a full understanding of his rights and the consequences of choosing to testify and the protection he gets in the form of the legal instruction that I'll give the jury by electing not to testify. And that's how it will be. Anything else, Ms. Wood, before we bring the jurors in?
Yeah.
Okay, let's bring the jurors in, please.
All right, the jury.
Thank you, Deputy Gordon. Welcome back, ladies and gentlemen, from lunch. Appreciate your patience while we worked through a couple things since we reconvened about 10 minutes ago. Mr. Hand, if you would call your next witness, please.
Yes, sure. The state would call Ms. Kelly Hooper.
Okay, Ms. Hooper, if you'd come on up, please.
You swear affirm that testimony will be able to be the truth, the whole truth, and nothing but the truth, so help you? You already have a seat. State your name for the record.
He's hard to hear because he was walking away and he had a mask on, but what he did say was he asked you to state your name and spell your last name for the record.
Thank you. It's Kelly Hooper, Hooper.
Thank you, Ms. Hooper.
Good afternoon, Ms. Hooper. Thank you for being here. Ms. Hooper, can you tell the jury what you currently do and where you work?
So right now I work for Home Depot Corporate Security as a corporate security analyst.
And where were you working December 12th, 2020?
At the Roswell Police Department,
What was your role at the Roswell Police Department?
criminal intelligence analyst.
Sorry?
Criminal intelligence analyst.
Okay. And what does that role entail?
So that entails a lot of the background work that detectives don't necessarily have time for. So it's social media work, it's cell phone data, anything like that.
And how long had you been at Roswell?
In total, I was there for 8 years.
8? Okay. And where was your role always as an analyst?
Yes.
And you said one of your duties was cell phone data?
Yes, sir.
Okay. And what would you do with cell phone data?
So in this, in certain cases, you would call, the detective would get a subpoena or a search warrant and send that to the provider. And based on what information they're asking for, we would map where the device was during the time that they requested.
And when you say map the device, what determinations were you making about the device?
Where the device was located. We had a mapping system called PinLink, and it kind of just made it look a little bit better to the eye than just go into Google and putting in some dots. So that's all it was.
And that cell phone data, who would provide it?
For which one?
Where would you get it from?
The detective.
Okay. And where would the detective get it?
Provider.
Okay. And when you say provider, you mean?
T-Mobile, AT&T, Verizon, so on and so forth.
Okay. And do you remember analyzing cell phone data in 2020 of December?
I remember helping on this case, yes.
Okay. In this particular case involving a hit and run?
Yes.
Okay. And did you do that?
Yes.
What did you do?
I did what I just said. So when the CDRs, or I'm going to say call detail records, CDRs and tolls interchangeably, but they're the same thing. You go and you look and see where the device was based on the time that the detective has told me to look for.
Okay, so the detective got data, gave the data to you.
Correct.
You're looking at the data to figure out where the phone is located.
Yes, sir.
Right? Okay. And where do you get do you also get the time zones from, time period? From the
Yes.
detective?
Mhm.
Also a date?
A date and
Or
a
the
time.
time
Mhm.
range?
Dates, yes. Mhm.
Just the state is showing the witness states
We're on 18.
18. Thank you.
Yep.
Judge, I don't know what he's showing with this.
Okay, well then he's not showing anything quite yet until he shows you.
Ms. Hooper, do you recognize this document?
Yes, sir.
What type of document is it?
This is the CDRs or the call detail records provided by T-Mobile.
And does it appear to be fair and accurate as you remember it to be?
Yes.
Does it appear to be altered in any type of way as well?
No.
Judge, before I move to enter this into the record, well, at the same time, I'd also like to tender to the court States 19, which is a business certification for States 18.
Okay, and you've shown that to Ms. Wood as well?
I have.
Okay, so 18 is the actual call detail records for some phone number. And then 19 is the certification from T-Mobile or the records custodian from T-Mobile in connection with those records. Okay, Ms. Wood, you've had an opportunity to review 19 also? Okay, or Ms. Feely?
Yes, Judge.
Team Christopher. Any objection to the admission of either states 18 or 19?
Yes, Your Honor. It's hearsay, and we don't believe we were served with notice that this particular evidence was coming in under the business records exception.
Okay, can I see 19, please? Thank you. And do you mind handing me 18? Thanks. Sorry for that little. Whoa. You can read this?
It's small.
Is. So Ms. Feely, your objection, I heard you say hearsay, but then also notice. So would if you had received 19 or really the notice that then would have this attached to it, that would cure the hearsay objection, because then you would have been put on notice that the state was going to rely on the certification to get in these records that are ordinarily kept in the course of T-Mobile's business.
And we got that States 19 on Friday.
Okay. And since Friday, has reviewing States 19 given you any reason to believe that T-Mobile doesn't ordinarily in the course of its business keep records like States 18?
Yes, that was generated from a request from, it's not regularly kept information.
I'm confused. I mean, if they were able to generate it from their records,
We don't know who did that. So this came from the provider, but we don't know how they got his information from. This is not something that is kept in regularly conducted business.
Okay.
This is something generated by the police department's request. And we also question whether, we haven't heard very much yet, that whether this witness is qualified to interpret this data.
We'll get there, I suspect. I'm going to allow in States 18 and 19. 19 is the certification from a Jackie Borland, Bourland. It contains the necessary attestations from her as to the source and origin of the records that were requested by, it looks like it's Officer Ramuno, from whom we've heard, and his search warrant, and it affirms that S18 is what was yielded as a result of the inquiry from the Roswell Police Department. So I hear your objection, overrule it. Anything you want to add?
Not at this time.
Okay, thanks.
Ms. Hooper, can you state again for the court what the document is that you're holding?
This is a document provided by T-Mobile, and it's call detail records that were requested by Detective Ramuno.
Okay, and for what phone number was this record requested?
It's not on this page, but by looking at it, it looks like it ends with 8292. I could be wrong because it's not
Do
actually.
you have the phone number on there? You
I
give
think
it?
it's small, 678-254-8292.
And I know you stated for 8 years you were an analyst with Roswell PD. Had you worked as an analyst analyzing cell phone records before that as well?
Yes. So from January 2009 through October 2014, I worked for the Cobb County Police Department, working in their organized crime intelligence unit.
And before that, did you work anywhere doing cell phone? No.
That was the beginning, 2009.
Okay. And from 2009 until today, can you quantify the amount of cases? I know it's done.
A lot.
Can you quantify the amount of cases that you worked on doing cell phone data analysis?
Almost daily on multiple cases.
Come on.
Is it hundreds or thousands?
Almost thousands, low thousands.
Okay.
And what's the special training that you received in order to analyze cell phones?
So there's multiple. We do training through the GBI. It's called GTIP, Georgia Terrorism Intelligence Project. And they take analysts throughout the whole state and give us training. We do the pin link training like I stated earlier. And a lot of it is calling the providers and asking them to explain these records because every single one is different. So T-Mobile may look like this, and then AT&T looks like something completely different. So we like to talk to the providers to understand what they gave us.
And so are there any special certificates that you possibly have related to cell phone analysis?
Yes, but I couldn't tell you when or where they came from. It's been a long time.
Okay, is there any continuing education that you have to?
The GTIP that I'm not a part of anymore since I've gone corporate. They do yearly annual training.
Judge, at this time, the state would request to tender Ms. Cooper as a cell phone data analyst expert.
So what kind of notice did you give to the defense that, well, I'll let Ms. Feely make her objection.
We learned together just now. We had no notice of that.
Okay.
I don't think that has met the qualifications to rise to the level of expert, what we've heard so far.
Okay. I agree. I think you can continue with your questions. You just need to be careful if you're going to ask an opinion question as opposed to a fact question. What is this? And what does this mean, et cetera? But if you're asking an opinion question, then you may be straying into an area where you're seeking to elicit an expert opinion as opposed to a lay opinion about what one should conclude from X or Y or Z. Does that make sense?
It does, Judge. I guess my request would be that since the jury has already heard opinion evidence regarding cell phone data, that because it was already allowed in, that that objection had already been waived as far as opinion around the exact same cell phone data.
Okay. I'm remembering what you're remembering. I'm not interpreting it that way, that an objection was waived because the jurors may have heard something about a conclusion that Ms. Hooper reached before. But you're free to ask her about that, and you're free to ask her about the meaning of the records that are before her. And Ms. Feely will object, I suspect, if she feels like it's not actually plain from the records, but it involves some expertise.
Understood.
All right.
Thank you. Ms. Hooper, looking at that document, can you explain just in general what's on it?
In general, it has the search warrant number, the date. I guess it was requested, all the Roswell Police Department information, the dates and times that were requested. However, they're in UTC. At the top, it does state that we requested times or the date and time of December 12th, 2020 from 3 a.m. till 11:59 p.m. that same date. It has the call type, direction, numbers dialed and answered, your MZ number, your IMEI number, and your cell tower information.
And you said it's in UTC format.
Yes.
And what does that mean as far as our time zone? If we
It's
wanted to,
5 hours ahead.
okay. So if you were looking at a time on there, you would just subtract 5 hours from it.
Correct.
Okay. So, for instance, my apologies, Judge, can I have 1 second to? These are right there.
Sure.
So are there phone calls, specific phone calls listed on this worksheet?
Yes.
Okay, and so if it showed a time, for instance, let's start with the
First time is 8:14
okay, so it's 8:14, but that's which time zone?
UTC
Okay, and so is it 8:14 AM or PM?
AM.
Okay. We know that because it's in military?
It's in military. It's 0814.
Okay, so in Eastern Standard Time, which is our zone, what time is that?
3:14
3:14
AM.
Okay. So what is happening with that first timestamp as far as the phone call? Or what type of data transmission?
It's an outgoing, it looks like a cell phone call. However, there is no tower information connected to it.
And what is it? So there's no tower information. Well, if there were tower information, what would it?
It would show you the tower number and the azimuth, if it's there, and the azimuth is getting a little bit detailed, but it shows that there's 3 sectors per tower. The azimuth is the middle of each sector, so it shows you which part of the world it's pointing to pretty much. And then it also shows the address of the actual tower itself and the lat and long,
Okay, and when you say Latin long, what do you mean?
latitude and longitude,
Is that the location of?
the tower.
Okay, and what does it mean if the tower location is listed there?
It means that that phone connected to that tower
Okay.
at the date and time on this spreadsheet.
Does it mean that phone is near that tower?
Yes.
Because it's connected?
Mhm.
Okay, and for the first entry, because there's no tower information, what does that mean?
It looks like it's a failed attempt at an outgoing call. So it did not connect to a tower.
It did not.
Correct.
Can you tell then where the phone is at all?
No, sir.
Okay, so we started 3:14, what's the next?
The next one is 0815, so it would be 0315.
Okay, so about the same time?
Yep.
Is there any tower information listed?
No, sir.
Okay, what's the next time zone?
It is 0816,
Okay,
and it's the same. There's no tower.
excuse my hand. No information.
Correct.
What's the next entry?
It's 0956.
Okay. And subtracting 5, what time?
456.
Okay.
And that's the first time that there is tower information.
And if you were looking at what you have in front of you, which you are, and looking for tower information between, at 4 AM specifically,
Correct.
is it there?
No, sir.
If you're looking for tower information at 3:30 AM, is it there?
No, sir.
So if I understand you correctly, the first time we have tower information is at 4:56 AM.
Yes, sir.
Where can you determine based on the spreadsheet, is the tower at 4:56?
It is at 643 Dill Avenue, Atlanta, Georgia, 30310.
Is it 643?
Yep, Dill Avenue Southwest, Atlanta, 30310.
Okay. So in this case, there was a hit and run, if you were told that there was a hit and run about 4 AM.
Mhm.
And given this spreadsheet, could you tell where the phone was at 4 AM?
No, sir.
In this case, do you know if there was a supplement made to the police report, just an additional report to the police report about the cell phone records?
Yes, sir.
How, do you know who made that supplement?
Detective Ramuno.
Okay. Do you know what he put in that supplemental report?
He stated that I told him that the phone was not in Roswell at the time of the incident.
Did you tell him?
No, sir. I told him I could not figure out where the phone was at all until 4:56.
Until when?
4:56.
That Dill Avenue hit.
Yes, sir.
If you did have cell phone data for that time period at 4 AM-ish, would you have made a supplement yourself to the police?
Yes, sir.
Did you make a supplement at all to the police?
I did not because I had no information, good or bad, for it.
So if you had information showing the cell phone was not there, but somewhere else, would you have added a supplement?
Yes, sir.
But so far, you're saying you had no information
Correct.
at all.
Correct.
Is there any information about in this cell phone data regarding Dogwood Road?
There is.
What timestamp is there?
Can I rip this? Because I can't read this.
Yeah, yes.
I followed this correctly. It looks like that evening at 6:01, so it would really be 5 hours less than that. 101 or 1,300 hours.
That PM?
Yes.
Is that the only time it is about the road?
It is there. Until 1940. So it'd be,
Until?
it hits 1, 2, 3, 4 times off the 9695 Dogwood Road, Roswell Tower.
Until, and you said 1940,
Yes, sir.
which would be, that's not showing, so 440? Is that right? That is in there.
Be 7 minus 5.
So,
It's 240. 240.
Sorry, I'm intertwining military and regular. It's hard.
okay, so it's 240?
Yes.
Okay. So if you were asked to find the location of the phone between 1:01 PM and 2:40 PM, based on that data information,
It
what
hits,
location?
I can't tell exactly where it is, but I know it connects to the Dogwood Road Tower.
Okay. Is there? One moment. No further questions, Judge.
Ms. Feely.
Do you remember emailing with my staff yesterday morning?
Yes.
And do you remember speaking with an investigator with my office yesterday morning?
Yes.
Do you remember telling him that you didn't remember anything about this case?
Yes.
But now you do.
Once they showed me this.
Thank you.
Any redirect?
No, Judge.
Any questions from jurors? Ms. Hooper, I appreciate you coming down here. I understand we kind of swooped in and disrupted things a little bit. Appreciate your flexibility. You can leave S18 and 19 right where they are and they'll be reassembled.
Thank you.
So it's my understanding, Mr. Hand, you've got one more witness. That witness is en route.
I believe so, Judge.
Okay. Do we have a rough ETA just so we can let the jurors know you're having an early afternoon break here?
I believe 15 to 20, Judge.
Okay.
I was told.
I don't doubt Mr. Malkin, but there may be someone in closer contact with the witness. Okay. Just want to manage your expectations, whether it's 15 minutes or 20 or 10. And your expectation is that the witness en route would be the state's final witness?
Yes.
Final witness. Okay. And Ms. Wood, you'll have witnesses available should you be choosing to call any witnesses after the state rests?
Yes, sir.
Okay. Why don't we do this? Because I don't mean for you all to wait here in court. You're going to be taking a break anyway, so you can start your break. Please don't talk about the case or do any outside research. When we learn the expected arrival time of the last witness, I'll have Deputy Gordon tell you, because you may say, I'm going to dive in and do some work. And if you know it's 10 minutes, you may do something differently than if it's 15 minutes. It is minutes, not hours, that we're waiting, and then the state will rest and we'll see where we go from there. So enjoy your early break, and we'll get you back in here, excuse me, as soon as we can. Thank you. What's the update?
20 minutes, Judge.
20 minutes. Okay. It's on 15 minutes. Can we start our charge conference now? Folks are good?
Some more things on the record.
You get as much as you want on the record, but then we're going to start our charge conference. Are you good with that, Ms. Rivers, or do you need a break? You're good? Okay. You all can be seated. All right, Ms. Feely.
Yes, we wanted to just perfect our objection to that document coming in based on the hearsay contains the confrontation clause violation and the fact that it was not a record kept in ordinary course of business. It was generated for this trial. So it is not an exception to hearsay. And so I needed to say that. And also this witness was not actually qualified as an expert and yet gave expert testimony by reading the report, essentially, by reading the hearsay report.
Okay. Noted. Do you want to add anything from the state side?
Yes, Judge. Judge, as the certificate states, the data that underlies what was sent, which was raw data, was regularly kept information. It was not manipulated in any type of way. It was just provided to the police department. And so we don't believe it's hearsay at all, as well as for the expert testimony, Judge. She simply stated what information was there and what information was not present. There was no interpretation of what a tower means if it has a switch and another code to it. It was very much what I would believe to be lay information and not expert testimony.
Okay. So the objections are preserved and they were further fleshed out through Ms. Feely's comments. I'm not changing my ruling. I will observe that I find that the information that T-Mobile sent, T-Mobile does keep in the ordinary course of its business. It's not a report in the sense that Mr. Christopher was receiving each month that level of detail, like we might think of bank statement, which is another classic business record that we usually don't make someone from Bank of America come in if we had Mr. Christopher's August 2021 bank statement. But the data that is contained in States 18, I believe, is ordinarily kept in the course of the business, and it was merely organized in a way that was responsive to the request from law enforcement in a way that is very, very routine for T-Mobile and Verizon and every other cell phone provider in the United States. Every day, they generate thousands of these types of reports. So I find that it's not hearsay. Our witness knew more about cell phone records than some people, maybe not juror 23, but than most people. But I don't find that she provided expert opinion testimony. I would analogize this to had Dr. Haynes been here. I don't think you'd have to qualify him as an expert for him to say, this is what the medical records say. It was a broken ankle and a facial fracture, and I treated it in this way. If you were to ask Dr. Haynes, and in your medical opinion, was this an injury from which he'd ever recover, or will he always have a limp? Then we're getting into using that specialized knowledge to reach a conclusion. And I don't find that that's what this witness did. This witness shared what the record said in a way that I saw what they said when I was given these records several days ago. But that is certainly a valid challenge by the defense. It is preserved. And if this is a verdict that's not favorable to Mr. Christopher, it is certainly something that an appellate court will need to work through. It didn't need to be this close call, but that's how it has unfolded. But I am ruling the way that I did. Ms. Feely, anything else you want to get on in the record on this issue? Okay.
Your Honor, can the state make one more observation on this issue, please?
Yes.
Okay.
And I'll let Ms. Feely respond if she needs to.
Absolutely. So the state wasn't going to bring this up, but in light of objections that have been made, the state has become aware. We had the conversation this morning, 9:15, 9:20.
We who?
Everybody in the courtroom.
Oh.
Hey, Your Honor, defense counsel, state counsel, about Ms. Hooper and her being under subpoena by the defense. And it was observed that it might be disingenuous if they were to notify her not to come in or to be released from the subpoena. Subsequently, the state did learn that at 9:35 this morning, Ms. Hooper received a call from the public defender's office from an assistant chief. I don't know if that's an attorney or an investigator, but somebody who's an assistant chief with the public defender's office, informing Ms. Hooper that, number one, she was released from their subpoena, and number two, she did not need to come to court today. And so the state was able to cajole her to come to court today. And so, that was that. But just in light of that specific conversation this morning about how that wouldn't be the right thing to do and that it happened, and in light of the objections as to the admissibility of the record and her testimony, the state felt like it needed to at least put that on the record. And I don't know if that would add to any relief that the court, or any decisions that the court has made or not, but the state just wanted to add that. Thank you.
Okay. Let's talk about the charges, please. I'm going to put them up on the screen as well. I can get them. And Mr. Hand, one of your colleagues will let us know as soon as Fortunato is in the building.
That's my understanding.
What I want to avoid is that he's waiting outside because people are thinking we're doing our charge conference. We will stop what we're doing as soon as he gets here.
Sorry, he was there.
Okay, on your screen should be the charge that you were emailed this morning. It includes, I think, all of the patterns you all asked for. I don't think Ms. Niles kept anything out. But the way we're going to work through it is I'm going to scroll to areas that I have a question on or a concern. And if in doing so, I've skipped over something you've got a concern on, say stop, and we'll go to where your question or concern is. So my first is under credibility of witnesses on page 4. I don't think that anyone has heard about any witness having been convicted of a felony. And so in terms of attacking a witness's credibility, I think I can remove that and not underinform the jury. Do you agree, Mr. Hand?
I agree, Judge.
Ms. Wood?
Agree, Judge.
All right, I'm gonna remove that.
Judge, well, we can talk through these. I wanted to, related to that, I wanted to request the addition of a jury charge.
Okay, we'll get to that. I think only one witness has been designated an expert, and that was Kowalski. So it used to be plural, but it's a witness. I will give defendant's choice not to testify. I highlighted that only because Mr. Christopher and I hadn't had our conversation yet. On page 5, limited use of certain evidence. I don't think we have that in this case now. Someone may have thought that might happen, but I suggest we not use that charge. Do you agree, Mr. Hand? Ms. Wood?
That's fine, Judge.
Okay. So hit and run. There is not really a pattern for hit and run because hit and run has a bunch of different permutations. I created what you now see highlighted on the screen. It's in the format of our new offense-specific criminal pattern charges where we say for, name your crime, the state must prove that, and then you list your elements. I have listed 3 elements. The first 2 are necessary elements for the way hit and run is charged in this indictment. The third is tailored more to it. The state has to prove that a defendant failed to do one or more of a whole bunch of things. If you look at the non-highlighted version, that 1 through, it's actually 7, but it's hard to have all of them on the screen at once. So if you look at the 1 through 6 that are on the bottom half of page 6, it is a crime. One commits the offense of felony hit and run if there is a collision with a pedestrian and the pedestrian is seriously injured. So those are the first 2 elements. And the driver of the vehicle that hit the pedestrian fails to do any one of the following 7. And so I could be literalistic and list all 7 of those, but the reality is it's any one of them. And really none of them happened because they all involve the driver stopping and staying on the scene. But if he stops and stays on the scene and refuses to give his name, that's a violation. If he stops, stays on the scene and refuses to show his driver's license, that's a violation, et cetera, et cetera. So my thought was to keep this as accessible to the jurors as possible. We summarize and distill those 7 into what I have as element number 3, which is that the defendant, this is what the state has to prove, the defendant failed to stop and remain at the scene of the accident until aid was rendered to the pedestrian. And that actually captures a couple of those 7, because one of them is that the driver is supposed to try to render aid, or if not, make sure that aid is summoned. And even there's an obligation to transport the person to the hospital. But I don't think we need to get into any of that because I think number 3 captures it. There's not a pattern for anyone to point to say, no, judge, do it that way. My focus is always on accessibility as long as I am not in any way reducing the state's burden or requiring the state to prove more than it is statutorily required to do. I think this does that, but it's the main charge in this case, so everyone needs to be comfortable with it. Mr. Hand, what are your thoughts about the highlighted language?
Judge, I had submitted, I think, 2 pattern charges, but I wasn't sure if they were applicable. And so I just submitted both and thought we'd discuss it here at the charge conference.
We will.
However, I think this more accurately describes what's actually in the statute, OCGA 46-270.
So I'm looking at your submission and you, oh, I see. You have 28620 and 28622, leaving the scene, hit and run, and then leaving the scene, hit and run felony. Ms. Niles looked at those and didn't think that they covered everything. And so she had crafted something, as my staff attorney. And then I took what she did and further synthesized it to what's highlighted.
Okay.
Let me check with the defense. What are your thoughts about the language that's highlighted for the elements that the state must prove beyond a reasonable doubt?
We have no issue, Judge.
Okay. That's what I'm going to go with. If we move on, false report of a crime, there is no pattern. This is just basically, I moved some of the words around from the statute. But that's how it used to say is a misdemeanor. I took that out. It's not the jury's business whether it's a felony or a misdemeanor or whatever. Ms. Niles is correcting me. The ones she put in were the pattern ones as opposed to something she came up with. Either way, I like what I did. And it sounds like that's what we'll go with. Accident. I highlighted accident because we need to talk about this. I worry that a charge on accident is going to unnecessarily, maybe even improperly confuse the jury. I'll keep talking about it if it was a defense request. If it was a state request, I'm not giving it. If it's a defense request, then we need to have some dialogue before I make my pitch for not giving it. I can find out because I have.
It's not a state.
It's not a state one. I'm looking. So let me explain why I think it's misleading. Not that you included it, but accident is a powerful defense when my gun accidentally went off and someone got shot. This case was an accident. There is no allegation that Mr. Christopher intentionally hit Mr. Duffy. In fact, that's part of hit and run, is that you got to stay at the scene of the accident. And I worry that if I charge the jury on accident, they're going to say, wait a minute, there's no crime because Mr. Christopher didn't mean to hit Mr. Duffy. But the state doesn't have to prove he did. In fact, if you felt he intended to hit him, it's aggravated assault. It's not hit and run. So I think accident is misplaced. Because it goes to that classic, I didn't know the gun was loaded, or I picked up my luggage and that knocked into the gun and the gun went out. It was purely accidental. And it's an appropriate and powerful defense. It's basically sort of, it's not justification, but it excuses the defendant's unintentional conduct. But that doesn't seem to fit in this case. In fact, it so misfits that I think it is confusing.
Understood, Judge.
Okay, so no objection to omitting that. All right. So then knowledge. I need you, Ms. Wood, or you, Ms. Feely, to explain the knowledge part here. Because again, that has a role. In some cases, it's typically a drug case and you're able to show that the person had no idea there was cocaine in the bag, or that what was on the table was cocaine. I was just a visitor and I had no idea. And there's literally a box of baking soda on the table. And how was I supposed to know this other white stuff was cocaine? It's not mine. That doesn't seem to fit as well in this case.
Given how the evidence has come out, we'll withdraw that.
Okay. And that's all I've got. Let me put the verdict form up for you to look at. And then, Mr. Hand, I will hear from you, and I'll certainly hear from the defense if there are things not in there that you thought should be, or something that's come up that you want to add or take out. Let me find the verdict. Is it on the screen now? I don't know how this, or is it still the jury charge?
Jury charge.
Jury charge? Okay. hold on. It's a pretty benign form. Mr. Hand, any issue with the jury, the verdict form?
No, Judge.
Ms. Wood?
No, Your Honor.
All right, we're set. It's printing out right now. That's how real it'll be. Let's go back to then the jury charge.
Our last witness is here, Judge.
Okay, but we, what happened? Here we go. What was it that you wanted to add?
Judge, the state would request the addition of prior consistent statement, that charge, as well as the date of the indictment being immaterial. I forget the name of that charge, but maybe just.
Why, is it because it was 4 a.m. technically on the 13th instead of the 12th?
Yes.
Oh, okay. If you can get that language in an email, or the number from the pattern, that's easier if you, however you do it. Please copy Ms. Wood and Ms. Feely on that email, but get that to Ms. Niles and me. Prior consistent statement, I will weave it into credibility. It won't be a standalone. In fact, let me see if we look at credibility. It's not specific enough to prior consistent, so I'll probably add a little language, but it will fall under credibility of witnesses. It doesn't mean I won't put the language in, just there's not going to be there probably won't be a standalone about prior consistent statement.
Okay.
And the other was the materiality of the date.
Yes, Judge.
Okay. Well, don't look for it right now, just because Ms. Feely's got something too. But if you will. Ms. Feely.
Yes, while we're adding things, we would request impeachment. And it is 130.31.00.
Okay, I think that I may need to make it more explicit, especially if I'm adding consistent. Yes is the answer. I typically meld those into credibility because it's all part of that package. But I will look at the language for impeachment, and what I'll share with this group is the revised credibility of witnesses charge, which will address prior consistent statement as well as impeachment, because that if it's not sufficiently in there, it needs to be more in there. And then we can have a discussion if we need to about the materiality of the date in the indictment. So if you could just put in an email, the pattern number, and share that with Ms. Niles. Okay. And of course, you'll get a final version of this before we charge the jury. Can you check to see if the jurors are ready? Don't bring them in yet, but if they're ready, then I'll make sure folks here are ready. Thank you. They're good? Okay. Mr. Hand, are you ready for the jury?
Yes, Judge.
Ms. Wood,
Ready, Judge.
let's bring him in, please.
All right, jurors.
Thank you, Deputy Gordon. All right, Mr. Hand, everyone is ready for your next witness.
Yes, Judge.
That'd be your computer. Oh, and George Jenkins. Mr. Jenkins, mute yourself. I took care of it.
It's still going, Judge.
Better? Everything was working before George Jenkins joined the call. There we go. All right.
Judge, the state would call Sergeant Fortunato to the stand.
Do you swear or affirm that the testimony you will give is the truth, the whole truth, nothing but the truth, so help you? Go ahead and have a seat. State and spell your name for the record.
Sergeant Joseph Fortunato, Fortunato.
Judge, when you read the.
Yes, thank you. Mr. Hand, if you don't mind, or Mr. Malkin. Thank you.
Good afternoon. Mr. Fortunato, can you start by telling the jury where you work and what you do?
I work for the Roswell Police Department. I'm currently assigned to the Uniform Patrol Division as a patrol supervisor, as a sergeant.
And what are your duties include as a patrol supervisor?
Approving reports, day-to-day operations, going on calls with officers, supervising the day-to-day of everything that's kind of going on the shift.
Do you remember investigating a hit and run in December of 2020?
I do.
Were you operating in the same role at Roswell PD?
I was on a different shift. I was on one of our night patrol shifts at the time, C Squad.
Okay. And do you remember responding to that actual hit and run location?
Yes.
Okay. Can you tell the court what you observed when you arrived there?
I believe it was a single pedestrian that was struck by a vehicle on the side of Grimes Bridge Road, or Dogwood Road, south of Grimes Bridge.
Did you and other officers look for items at that location around where the suspect was
Yes.
found?
Yes.
Were items found at that location?
Yes.
You know where items were found?
What I specifically remember is car parts, a beer can that had been smashed open, and a pair of headphones.
And do you know those items were collected by Roswell Police
I
Department?
believe they were, yes.
And if you were to see those items, would you recognize them again?
I believe so, yes.
Sergeant Fortunato, do you, can I approach the witness with this item?
You may,
Judge, I have, yeah, I would like to see it.
so then you may not.
Do you recognize this bag at all?
It appears to be a property evidence bag that we use.
Okay, is there a case name or case number on there?
There is.
What is it?
The case number is 2012-000381.
Is that the case number associated with this case for the hit and run?
With the hit and run, yes.
Okay. Are there any names of any suspects on there at all?
There is the name of a suspect, yes.
Okay. What name is on there?
It's Landon Christopher.
Okay. And can you recognize the items that are inside the bag? You can take a look.
And open it. It appears to be a side mirror for a gold car.
What about the other?
And there's several other car parts. Parts to either the front quarter panel or front bumper of a car. Silver broken car part. More plastic molding and pieces to a car.
And what about the smaller bags? You know, recognize that item?
Looks like the a ring to either a headlight or front fog light, which you'd have on a car.
Do you remember these being the items that were recovered from the scene on in December 2020 of the hit and run?
Yes, I specifically remember the mirror being recovered and parts of the bumper being covered and part of the headlight being recovered.
You did appear to have been manipulated or changed in any type of way.
No.
Anything added, any numbers or labels or anything that you didn't see from?
No.
Judge, at this time, the state would like to tender into evidence the physical items inside the bag that Sergeant Fortunato has at the witness stand. It states
So you're on 20?
20.
So you want the bag to be 20 and what's in it is just part of 20?
Yes, sir.
There's a separate plastic bag. I don't know, that was in the paper bag. Is that a separate exhibit? Okay,
Stapled to the bag.
all right.
I can do it separately if you would like.
Whatever's going to be easiest for record keeping. So we might as well make that separate bag 21. So paper bag 20, plastic bag 21. Ms. Wood, any objection to states 20 or 21?
No.
Ms. Feely, thank you. They're admitted.
Thank you, Judge. I'll split these stickers up. Sergeant Fortunato, these are the items collected, but you also, did you respond to the scene where, like a day later, on December 13th, did you respond to a scene for property damage?
Yes.
Do you remember what you observed when you got there? Well, let me take a step back. Where was that scene? Do you remember?
I believe it's the auxiliary parking lot for Pleasant Hill Baptist Church off of Oxbow Road.
Okay, was that also in Fulton County?
Yes.
Okay, and when you responded, who did you meet with there?
First met with Officer Lewis and Officer Bath, who were the initial responding officers.
Okay. Did you observe any civilians there as well?
Yes.
Okay, do you remember who was there?
I spoke with Landon Christopher there, and then a female who I don't remember her name as well that was there.
Okay, did you observe the vehicle that we claimed to be damaged?
Yes.
And Judge, I'm showing the witness states 11. Do you recognize this photo?
I do.
And how do you recognize it?
This looks like the car that was parked in the parking lot when we responded to a damaged property call.
And does that appear to be how it was damaged when you arrived?
Yes.
And looking at, well, first of all, one of the objects you have is a mirror. Is that correct?
Yes. Side mirror.
Is there any serial numbers or anything on that mirror?
And there's several numbers on it. I don't know which one is the serial number.
Is there a make or model on that mirror?
It says Toyota.
Does that mirror appear to be the same color as the vehicle from December 13, 2020?
Yes.
Okay. What about the other pieces? Do they appear to be similar in color or?
Well, there's some of these are silver molding and then clear, possibly clear plastic headlight. This piece is the same gold color as both the car and the mirror.
Okay. And can you tell where that piece came from or if it's consistent with the vehicle that you found on the?
Looking at the picture, it looks to be the exact piece missing from the front bumper where it meets the quarter panel right below the headlight.
And however, that piece was found at the hit and run location, correct?
Correct.
Further questions, Judge?
Ms. Feely or Ms. Wood, any questions for Sergeant Fortunato?
Yes, thank you. Were you considered the lead detective in this case?
No.
You just responded to both scenes.
Correct.
And you mentioned that the car was taken into Roswell Police custody, right?
I did not mention that.
Okay, but it was?
Yes,
Okay, and the car was processed?
I believe so.
Okay, that includes getting fingerprints?
I don't do crime scene processing, so whatever they would do for their normal process.
So to your knowledge, the car was processed for things like fingerprints and DNA?
I believe so.
And at the second scene, you mentioned a female being there also,
Yes,
and you spoke with her?
yes.
And she told you the same thing as Mr. Christopher about the car's damage?
She didn't say anything about the damage. She just said that she had picked him up in the parking lot and they spent the day together.
All right, thank you. Then further.
Any redirect?
Yes, Judge. Sergeant Fortunato, you mentioned you spoke to the other young lady at the location.
Yes, sir.
Did you ask her how she picked up, coordinated picking up Mr. Christopher?
Yes.
What did she tell you?
She said that he had called her that morning to pick him up.
Did you ask for any proof of that?
I did. I asked if I could see her call log to show that phone call that existed, and she told me no.
Okay. Did you ask that same question of the defendant?
Yes.
What did he say?
He said that he FaceTimed her and I asked for the same, if I could see that in the call log, and he said no.
You found that suspicious?
I did.
No further question.
Any redirect? No? Any questions from the jurors for the sergeant? No? All right, Sergeant, thank you for being here.
Leave all this-
Yeah, you don't, that's not your problem. Just don't knock it off as you get out. Thank you, sir. Mr. Hand, next witness?
Judge, the state would- Actually, Judge, the state would request to tender states 22, which are the medical records.
All right. Ms. Wood, any objection to making the medical records part of the record in this case? Again, whether they go back with the jury or not, TBD, we discussed that, but any objection making them part of the record?
No objection.
All right, S22, medical records admitted.
Thank you, Judge.
You bet. Beyond that, tendering, any other witnesses?
No, Judge, the state would rest.
The state rests. Okay. Ms. Wood, there may be some motions we need to work through, and I'm happy to do that. I'm wondering if we want to just thinking schedule wise. I'm gonna have you all take a quick break. It will be shorter than the last break you had, but as I had previewed for you when I gave you these initial instructions yesterday morning, once the state rests, there are a couple things that the lawyers and I need to talk about outside your presence. So please go with Deputy Gordon, and we'll get you back out here shortly. Thank you. All right, you all can be seated. Ms. Wood or Ms. Feely, anything we need to talk about before we figure out if you're going to be presenting any evidence?
Move for a directed verdict of not guilty on both counts.
Okay. Are you relying on the record, or do you want to make specific argument?
We would argue that there has been insufficient evidence placing Mr. Christopher in the driver's seat of the car, which is required. There's no duty on a passenger according to the hit and run statute, as well as the false report of a crime. I don't know that there has been evidence that shows that he gave a false statement as it relates to the hit and run as described in count one. He may have made a false statement about his car being how that didn't happen at the church parking lot, but there hasn't been evidence that he made any statements regarding the actual hit and run that we're looking for.
Okay. Mr. Hand or Mr. Malkin, response?
Judge, as it relates to the first comment, the state does assert that there has been more than enough evidence to show that the defendant was the driver. It being his car alone and him stating that he had the only key that was access to the car is supportive. Also, we had an eyewitness, Ms. Kayla Newborn, who stated that she was in the car with him as a passenger and he was the driver. The statement given by Ms. Katie Newborn, who is her cousin, also stated that he was the driver of the vehicle that night. Judge, there has been no evidence to rebut that he was not driving. There was no inconsistent statement from any of the witnesses saying it could have been someone else. All of the evidence pointing to who the driver was of that car was Mr. Christopher.
Okay. And count two.
For count two, Judge, this is false report of a crime. That count only requires that a false report is being made to.
So here's the wrinkle. I know what the element is because we just talked about the jury charge. The indictment says that Mr. Christopher committed a false report of a crime when he told law enforcement officers something false concerning the involvement of his vehicle in a hit and run. In other words, the hit and run in count one. What Ms. Feely is saying, hey, we heard what he told law enforcement. It was, I parked my car here on this day, later than the hit and run, went to go be with Ms. Newborn, and I come back and someone smashed up my car. And the thrust of the state's case is, well, that was false because, of course, your car got smashed up during the hit and run. But as I understand Ms. Feely's argument, Mr. Christopher didn't say to the police, someone else drove my car during the hit and run, or there was no, how does his, from your perspective, false claim that someone else hit his car while it was parked in the parking lot, what does that have to do with the involvement of his vehicle in the hit and run that would have necessarily been at a different time?
Well, Judge, we all watched the body camera footage of his conversation with the three different officers, Fortunato, Bath, and Lewis, and he is heard saying more than once that it wasn't his car that was involved in the hit and run. Sergeant Fortunato told him directly, I want to tell you that I don't believe what you're saying because his car was involved. He's like, not my car. That statement that his car was not involved in the hit and run 2 days ago, where he says he was at his girl's house or somewhere else, that statement is a false report involving that crime.
But that would be maybe a false statement But what's charged is false report of a crime. 911, hey, I'm reporting criminal damage to property, or maybe even I'm reporting a hit and run, because it's also hit and run to hit a stationary car and drive away. So it's not false statement, it's false report of a crime. So
I would say, Judge, they're interrelated incidents. So he's making a false statement in the form of reporting a false crime. Like they're both happening simultaneously. By him saying his car was not involved in that incident, but was in the proof was that he parked his car that morning at this lot where it was then damaged. It's both in one. And so the state would argue that his statement that his car wasn't involved because it was in that lot all day where it was actually damaged and not the other location is a false report of a crime related to the crime that the officers were investigating.
okay, got it. As the movement, anything, thank you. Anything you want to add, Ms. Feely? You don't need to, you're the movement.
He makes statements about his car not being involved in a hit and run, but it doesn't specifically pertain to count one. And it is, even if that was a false statement, what the court pointed out is it doesn't fit the statute of false report of crime. He's not reporting the crime count one was charged.
Right. So, Mr. Christopher, the motion your lawyers have made is an appropriate motion at this time. It is a bold one only in the sense that the burden to prove this motion is real high. If I find that there is any evidence that would allow a jury to reach a verdict of guilty, I have to deny the motion. And I'm denying it as to count one, because there is some evidence that a jury could reasonably rely on to conclude beyond a reasonable doubt that you were the driver of that Toyota Highlander. And that was the argument, that you weren't the driver, not that that vehicle wasn't involved in the hit and run. I think there's plenty of evidence of that. And so Ms. Feely was very refined in her argument. And it's that the state hasn't shown that you were driving. That car may have been involved, but maybe Ms. Newborn was driving, or a friend of yours was driving, who knows, but it wasn't you. But there is some evidence. If the jury decides to credit Kayla Newborn's testimony, that puts you behind the wheel of the car when Mr. Duffy got hit. I'm not saying that's what the jury will do, but they could. And if they did, I would not overturn that verdict. So I'm denying it as to count one. Count two, I'm going to dismiss. I guess I'm granting the motion. It's not a proof issue. It's how count two is written. And shame on me for not having read it more closely before. But what count two alleges is that Mr. Christopher falsely reported a crime. And the thrust of the state's case has been he falsely reported criminal damage to property, or a different hit and run, the hit and run on the 13th in the church parking lot. And I think there's lots of evidence that he falsely reported a crime of that nature, but that's not what he's charged with here. The actual charging language is that Mr. Christopher gave a false report to the law enforcement officers regarding the involvement of his vehicle in the hit and run in count one. And I think the jury will decide whether he did. He did say to them, I don't know what you're talking about. My car wasn't involved with that. I wasn't driving on Dogwood at 4 a.m, etc. But that's not a false report of a crime. That's a false statement. And so unfortunately, the author of count two, which was not Mr. Hand, conflated the two. There is evidence that Mr. Christopher falsely reported a crime of a hit and run on his vehicle as it was parked in the church parking lot. And if the allegation stopped with the word accident, accused did give a false report to law enforcement officers regarding the involvement of his vehicle in a hit and run auto accident. Stop. That's what's happened, because he basically said, hey, someone hit my car and drove away in the church parking lot. And maybe it's criminal damage to property because they use a sledgehammer instead of a car, but I think that would be close enough. But the sentence goes on, as described in count one, said accident which caused injury to Matthew Duffy. So what the allegation is that Mr. Christopher gave a false report to the police concerning the involvement of his car in the hit and run of Mr. Duffy. He did do that, but that's not a false report of a crime. That would be a false statement to law enforcement, which he's not charged with. And so really this should have been subject to a demur and it would have been tossed out then. But this isn't something that the jury could pass a verdict on, because if they said you proved what you allege here, you also proved count one by proving it, but you're proving that when Mr. Christopher told the police in the church parking lot, I don't know what you're talking about. I was not involved as the driver of a hit and run on Mr. Duffy, nor was my Highlander. That's the false statement, but that's not what's charged here. So I think it's appropriate to withdraw count two from the jury's consideration. Mr. Malkin.
Thank you, Your Honor. Could I just say a couple words that regarding count two, that and perhaps it would be helpful if we listened to the defendant's 911 call again to hear exactly what he said. But he reported a damage to his car, and I believe he said in the 911, or may have said, that there was a hit and run, that somebody might have hit his car and left. That impliedly is regarding the involvement of his car the day before, because if he is falsely reporting that his car suffered damage that day in the church parking lot, that's untrue, and it involves the hit and run the day before, because impliedly that means the car was not involved in a hit and run the day before. So it is regarding the involvement of his car in a hit and run the day before. Not very artfully worded, but the state believes a rational trier of fact could find the defendant guilty of count two the way it is worded. And again, maybe it would be helpful to listen to the 911 again.
I think if the 911 said exactly what you said, you still have a problem, because if this count, the only crime it alleges he falsely reported is the hit and run in count one. So it's either deficient in that it is, while it says false report of a crime, it alleges false statement, or it's deficient in that it doesn't refer to what crime is being falsely reported. The crime of false report of a crime is you tell the police this crime occurred and it didn't. Not you say a crime didn't occur and it did. That's a false statement to the police officers. But the statutes that is invoked and the name of the offense, and it matches 16-10-26 is false report of a crime. The element of that is you tell the police that a crime occurred and it didn't. And he does say that, but what Mr. Christopher says is someone hit my car. And that's what, I'm not changing anything what you guys been doing. It was criminal damage to property, maybe it's hit and run, but the thrust of the false report is Mr. Christopher is telling the police, and it's false. I think the evidence is showing that no one hit your car in the church parking lot. No one took a baseball bat to your car, but that's his story. And that's what he has Ms. Newborn say. It's your theory of the case. And I didn't connect it in count two. Count two ought to say a false report regarding damage to his vehicle. And it doesn't. It says he gave a false report concerning the involvement of his vehicle in not just a hit and run. It does say the words a hit and run, but then it goes on to say as described in count one. So that he gave a false report. So I understand that indirectly, if he is saying, wait, my car was damaged in this way and not in the hit and run that everyone's worried about, that's misleading to the police, but
false.
Right. But that's not a false report of the false report of the crime. What's the crime that is being falsely reported? It's not described in count two. There is either a deficiency because the crime that is being falsely reported is not identified. It would not survive a demur. He doesn't know what to defend against because what crime did he falsely report? It's the criminal damage to property or the faux hit and run in the church parking lot. The other way it wouldn't survive a demur is he could admit that he told the police I don't know that he'd want to, but he could admit, I told the police falsely that my car was not involved in the hit and run on Matthew Duffy. He could admit to all that. That's not false report of a crime. That is another way that you can show that a charge is deficient. So it's both special and general demur, not filed in this case, but it's not too late for me to say I'm removing count 2 from the jury's consideration. I'm not going to tell him why. Maybe he pled to it. Maybe I dismissed it. Doesn't matter. But I just don't think it's appropriate. And I would vacate a conviction on that count if it did go to the jury. So I don't think I need to charge them on that. I can take it off the verdict form, and I'll explain that we're now moving forward only with the hit and run charge. Your concern is noted. Anything else you want to get on the record in connection with count 2?
No, we will no longer need the jury charge on the date not being material.
Okay. Right. That's the one it wasn't count 1, it was count 2. Okay. Ms. Feely, I'm assuming you don't have anything you want to add. Okay. Let's talk schedule. One, I don't assume you're putting on any evidence because all that's left since Ms. Hooper testified is Mr. Christopher, and he's made clear he's not testifying. I feel like we could do closings this afternoon. I think we should. I'm happy starting at 3. So you got a few minutes to get organized. And of course, you could waive your opening and just do closing. But I'm reluctant to send the jurors home 2 hours early when I suspect we'll get through closings in 2 hours. We'll probably save the charge until tomorrow morning, but I'll take the jurors' pulse after closings are done. If closings end up being 20 minutes each side, then we'll also charge the jury, and I need to get to work on the charge. But that's my plan. So, Mr. Hand, you can be good to go at 3 o'clock?
Yes, Judge.
All right. You want to see if the PowerPoint's working?
I do.
There's this tech guy who wears a baseball hat from your office who usually makes it work. You may want to parachute him in here.
Okay.
You got 6 minutes.
Any chance we could have a little?
Does he not work with you anymore? He was in the clerk's office the other day filing something, and it was related to an indictment. Is he with the solicitor's office now?
You're talking about the legal assistant that used to work?
Yeah, the Asian guy with the baseball hat.
Yeah, he's no longer at our office.
But what's he was literally in the clerk's office in the indictment window doing something. Oh, I wonder if that was deep cover. Okay.
This is at the AG's office, I'm not sure.
Oh, maybe it was the AG thing. Okay.
Can we have a little longer than 6 minutes, Your Honor?
So I'd aim for 6, and maybe there'll be more. I got to go do one thing. If you'll let the jurors know, we're going to come in about 3 to do closing. Well, they need to hear some stuff on the record, but that we're picking back up in, say, about 10 minutes. Okay. Pardon me? We've got no credibility with them. They're good with credibility. They understand that.
You know what? It's just what a story is. Even though that story about. Because you want to show us. Thank you.
So the verdict form's gonna look a little different, just has one count on it.
Oh, it's in the stuff back.
Put the stuff in the bag.
Oh, please. I think he's gonna wanna be able to wave around that side view mirror. The mirror fits.
No.
You want the Stacy exhibits up there? Everything you fix.
All right, I'm gonna be back in a couple minutes, as in like 2. You feeling the readiness vibe?
Yes, Judge.
Excellent.
Call it his name.
Burning a hole. All right, Mr. Hand, you ready for the jury?
Good,
I'm going to test the PowerPoint.
yes.
Deputy Gordon, would you give one of these each 2 sides? Thank you. It's going. Excellent. Ms. Wood, ready for the jury?
Yes, sir.
All right, let's bring him in, please.
All right, so jurors.
Thank you, Deputy Gordon. Everyone can be seated. So hopefully you remember when you left a little while ago, the state had rested. We had to take up a number of matters that arise when one side rests. And we are now, as a result of the discussions that the lawyers and I had, moving forward with just one count. We're moving forward with a hit and run. You will not be considering during your deliberations the false report of a crime, just the hit and run. And it is time for Ms. Wood to let me know if you're going to be presenting any evidence or if you're resting.
Defense rest, Judge.
Okay. Ladies and gentlemen, the evidence is complete. You have heard all the witness testimony you're going to hear. You've received the physical evidence that you're going to receive, the documents and the car parts and things like that. Those will be available to you for your consideration during your deliberations. And we've reached the point now where the lawyers are going to make their closing arguments or summations. This is their opportunity to argue to you what they think you ought to do as a result of the evidence you've heard or haven't heard. It's perfectly appropriate for these lawyers to attempt to persuade you, but remember what I told you at the beginning of the trial. Nothing they say is evidence. This is now their synthesis or processing of the evidence. But if a lawyer tells you, you heard so-and-so say that it was raining that night, you're thinking, I don't remember anything about rain. It's your recollection that controls and not a lawyer really insisting that it was raining that night. The state has the burden of proof, as I've told you a bunch of times, and as I'll tell you again, which means in the context of closing arguments, they get to go first and last. They open and then they have a chance to rebut whatever we may hear from the defense. Of course, the defense has no burden. You may not hear a closing from the defense, but I bet you will. So, Mr. Hand, will you be opening and closing, or are you reserving your time just for the back end?
Both, Judge.
Both. Well, when you're ready.
Yes, Judge. Members of the jury, first, I'd like to say thank you for your time today. Thank you for paying attention to all of the evidence, all the witnesses, and everything that we've been able to put forth to you to consider. As I stated when I first came up here, when we started this trial, this case is all about a hit and run and a cover-up today. It began December 12th in the early mornings when Mr. Matthew Duffy took that stand. When we began, we talked about working a long 8 to 9 hour shift. He was working at North River Tavern, and while at that tavern, he didn't get off until about 2 p.m. He stayed and he closed down the kitchen, and he did say he had a beer as he was winding down. After a long shift, he decided he would leave about 3:30 after closing down. He decided to take what seemed to be a straight shot home down Dogwood Road up to his residence at 9955 Dogwood Road. He started that walk. As the hardworking man that he was at the time, being a line cook. He started that walk as a father of 2 kids. He started that walk as someone who was hoping to just get home to his family. He didn't foresee what would happen to him that night. As he started that walk, he got about 30 minutes into it, meaning just over his halfway point when he was struck. He was plowed by the vehicle that belongs to Mr. Christopher. He was plowed by a vehicle driven by Mr. Christopher. And he explained that that force excelled him forward. He flew through the air. He wasn't just hit and went directly to the ground. He said he remembered flying through the air. And so much force happened that it damaged the vehicle that Mr. Christopher was driving at the time. The mirror fell off, parts of the bumper fell off. Those pieces were brought to you today by the state. They matched that vehicle. While he was on the ground, that vehicle kept going. You heard from Ms. Newborn when she told you they kept driving. They didn't stop immediately. They kept going. Mr. Duffy was on the ground without glasses. He was unconscious. And he was bleeding. He doesn't know how long he was down there, but he somehow came to. He was able to find his phone and call for 911. But before he did that, he observed that there were no other cars around, that there were no other people walking around. Christopher Landon was nowhere to be seen, but he should have been there. He should have been there to render aid. He should have been there to call 911. He should have been there to make sure that Mr. Duffy got some type of assistance because it was his vehicle that struck him. It was him who struck him. But instead, he kept going. Mr. Duffy was able to get to the hospital that night. And then EMS came and took him to the hospital, and then police came and surveyed the scene. While they were looking around, they found pieces of his vehicle, the mirror, the bumper, and a few other pieces that came from that car. From the mirror specifically, you heard the officer state, Sergeant Fortunato, it says Toyota right on the mirror. So right off the bat, they knew the make of the car that they were looking for. They used the serial number on it to figure out it's a Highlander. That's what they were looking for. They put a bolo out, which is be on the lookout for this particular type of vehicle. That was December 12th at about 4 a.m. Afterwards, a 911 call occurred December 13th, full day and a half later, about 9 p.m. When officers arrived, this is where the cover-up part began. They were met with the defendant, Ms. Kayla Newborn, to say that their property, their Toyota Highlander, that was gold in color, that was missing a mirror, that was damaged in the front right bumper, also in Roswell, in the church parking lot, had been damaged. I don't know if you caught it, but there was testimony from Officer Fortunato on the body cam. He said that church wasn't even open that Sunday, likely due to the pandemic, but they weren't having services that day. But the defendant said when he parked, it was full of cars. Church was going on. Think about, was that truthful or was it not? And then when he spoke to officers there, immediately, one of the officers recognized the car from the photo. And he did say, that's our hit and run. He didn't know for sure, but they did take steps to confirm it. He went and observed the vehicle. Officer Lewis, the older officer with him, had a flashlight. He looked around the car. He observed it. He took photos of the car. He came and gave testimony to you today that there's no way another vehicle hit that car in that parking lot. Where are the car pieces? Where are the pieces that the state brought you today from a whole nother scene the day before? That's where they were. Because that vehicle driven by Mr. Christopher was a part of the hit and run the day before. He told you that there were no tire marks on the ground in the space right next to that car, the Toyota Highlander, to hit it. So this story invented by the defendant at the time was not possible. Why? To cover up the fact that the day before he was driving this vehicle at 4 a.m., he struck someone. After that, they told him, listen, we think this car is a part of a hit and run. We can't release this car to you. He became irate. He didn't even ask how his car could have been a part of a hit and run. He just said it's not possible. And Ms. Kayla Newborn, who was there with him, said the same thing. It's not possible. Well, how do you know it's not? It's just not. That's what we heard on the body cam. So they took the vehicle and they released them both because they couldn't place them at the scene at that point. They weren't 100% sure it was the same car. So they released them. Shortly thereafter, Mr. Landon turned himself in, February or March. She heard some testimony from Ms. Kayla Newborn. She found it out. He called her and told her from a different phone number, not the same one that she was used to him calling from. In fact, she asked him to call his old phone. Why? Because he had hid it in the bushes when he turned himself in. Does that sound to you like someone who didn't commit crime, like someone who's not trying to conceal a crime? And then, months later, we figure out the third part of this, the confession piece. Our office reached out to Ms. Newborn. In the moment we did, she didn't remember anything. I don't know, can't remember. Then she received text messages when she found out we were subpoenaing her to come testify. Those text messages didn't come from us though. Those text messages came from the defendant in this case, Mr. Landon Christopher. Not only did he say that, express that he was upset that she was testifying against him, he sent her a screenshot with her home address, with her brother's home address, with whom she was staying at the time. He wanted her to know, I know where you stay. I know that you're working to give information that's going to bring about me being in court and being convicted. That he knew. He sent that and it scared her. At that point, not only her safety was at jeopardy, possibly other folks in her family. And she, yes, felt for the victim here, but certainly had more of a reason now to come forward and be truthful. She stated from the beginning she wanted to tell the truth, but she was told not to for her own safety. So she came to us and she told us the truth. She said that this is what really happened that night. I broke up with my boyfriend, Mr. Jermaine. I was having a bad day. I wanted to go spend time with Mr. Christopher. So I took from my boyfriend's house a Jack Daniels bottle in my car, and I met Mr. Christopher on December 11th, that night at a QT. He parked at a pump. This is how detailed her description was. I parked on the side of the building. She took her bottle of Jack Daniels, she got in the car with him, and they drove off. They took turns drinking from a 750 milliliter bottle, consuming both in equal amounts per her testimony. They also went to a location in Atlanta, picked up cocaine. They were not just drinking, they were high. At 4 a.m., December 12th, the next day, they were still driving around. And she stated that they were on Dogwood Road when this incident happened. When this vehicle driven by Mr. Christopher plowed into Mr. Duffy. She told you that they kept driving, they didn't stop, but they circled around through another street just to get back on that same road. She didn't say he stopped, he circled around to come help whoever was struck. She said he circled around to look for his mirror because that is evidence that his car would have been there. He got out of the car first, walked ahead to look for the mirror. Ms. Newborn said she got out second. She did say that she was a bit high and she was a bit drunk at the time, but she remembers the event. She got out of the car, she was walking forward, helping him look for the mirror, and suddenly, per her testimony, he was about 50 feet ahead. He began running back. She said his body language was he was frantic. She didn't know why he was frantic, but he was in a hurry. He jumped in the car, but he told her also, you get in the car. She got in the car as well, and they drove off. There are also sirens being heard. So, but her statement, if you remember, was that she didn't hear the sirens until after they got in the car. So the sirens aren't why he ran back to the car. We all know why he ran back to the car. And that's because of what she mentioned he told her in the car. He saw somebody. He saw someone laid out, that's the term she used, laid out on the ground, possibly moving, but certainly a person laid out. And he drove away. He sped away. Per her testimony, they then went back to Atlanta, picked up some more drugs. She said she went with him because she was afraid of what would happen if she didn't. She did at the end of the day. Then they went up to a hotel and they stayed there. Her testimony is that she slept throughout the event. The point is that he told her here's what the plan will be. I'm not taking you home. We're gonna stay in this hotel. And he needed that time to figure out what he was going to do. He had that time. And he told her, as he was taking her back to her car, before he took her back to her car, I'm gonna take you back to your car. He did. She picked up her stuff, and then he told her to follow him. They then drove to a parking lot. I asked her, well, why'd you go to that parking lot? Had you been there before? She said she'd been there for a funeral, but never to this back parking lot that she was told to go to. Why that lot? She said because the defendant knew that there were no cameras in that back lot. He parked his car, she parked hers. He got out of his car, got into hers. And he said, this is what will happen. I'm gonna call the police. You're going to tell them, if you're asked, that I was with you all day. I dropped this car here at 10 a.m. You picked me up. And then I went with you to Cumming, Georgia, all day. You brought me back at 9 o'clock, and only then did we notice damage to this vehicle. She complied. When asked why, she said because she was afraid. This is someone who had past experience with the defendant and what would happen if she did not comply. She was afraid. So when the officers came and asked her, have you been with him? She said yes. When Officer Lewis said this car was in a hit and run, she said no, it wasn't. And she told you on this stand, she knows that she did not tell the truth. She knows that she could get in trouble for what she said, but she's here anyway. The defendant then left that location without his car. He was irate that he couldn't take his car, but they left. He turned himself in. Now we're here. We know what happened that evening. When we ask you to consider cases, we don't ask you to leave your common sense outside of the courtroom. It's the opposite. We ask you to employ it based on all of the evidence that we bring you. The state today has a burden. That burden is beyond a reasonable doubt. Not proof of all doubt, beyond all doubt. Not proof to a mathematical certainty. Not vague or arbitrary doubt, right? But beyond all reasonable doubt. That doubt is of someone who's fair.
Hold on one second. I think that's old Mr. Jenkins again. You can let him know that. Keep going. Sorry.
That is doubt of a fair-minded and impartial juror, honestly seeking just the truth. If there is doubt, it must be based on common sense and reason. As stated, it can't be vague or arbitrary. Your duty today as jurors is simply to seek the truth. What actually happened? Reasonable doubt. If asked, no one would doubt that this is the Statue of Liberty. Are all the pieces here? No. Clearly, there's a hand missing. But that doesn't mean that someone's going to doubt reasonably that this is the Statue of Liberty. That's what this means. Also, as jurors, you are bound by the instructions of the judge, which you will be given before you deliberate, and the facts of the evidence in this particular case. Now, when talking about evidence, there's two types of evidence. There's direct, and then there's circumstantial evidence. Direct evidence is anything that immediately points to the question at issue. Circumstantial are proofs of facts and circumstances that go to that issue. It's not a direct indicator of that piece of evidence, but it's indirect. An example is a gas station. We all, if we have cars, put gas in it, but we don't see the gas going to the car. What we do is we take a pump out, we put it into the car, we press it for about however long it takes to fill up, we take it out, and we see the indicator go from E to F. We didn't see the gas go in, but based on the circumstances and the ability of your car to continue to drive, right? We know that gas has gone into our car. The universe of evidence, witness testimony, witnesses, their testimony plus their credibility, the exhibits that were entered today, videos, photos, documents of any kind, and physical objects that you all saw today as well. Now, when looking at the credibility of a witness, you are to look at the manner in which the witness testifies, the interest or lack of interest in this case, means and opportunity of knowing certain facts, the nature of those facts, probability, improbability, all of those are factors of credibility of witnesses that you should consider as yours. The judge will instruct you that the testimony of a single witness, if believed, is sufficient to establish a fact. That's it. You just have to believe that witness. Generally, there's no legal requirement for corroboration. So let's now look to the elements of the crime that you're considering today. Today, we're considering one charge of hit and run. An element of that crime is intent, which may be inferred from proven circumstances. It can be inferred from acts, words, demeanor, motive. You can look at those things when trying to determine intent. The hit and run elements require the defendant was operating a motor vehicle that was involved in a collision of a pedestrian. The collision caused a serious injury to that pedestrian, and the defendant failed to stop and remain at the scene of the accident until aid was rendered to that pedestrian. Those are the elements of this crime. Now, regarding aid being rendered, what does that mean? It means the vehicle should immediately stop at or possibly close to that location, give their name, address, and registration number to the vehicle that person was driving. Upon request, show their license, render any assistance to the person injured in the collision. If it's apparent that medical treatment is needed for an injured person, make arrangements for that person to go to the hospital. But most importantly here, where a person is injured in such an accident that makes them unconscious or otherwise unable to communicate, make every reasonable effort to ensure the emergency medical services or law enforcement are contacted. Remaining at the scene and fulfilling any requirements that were previously mentioned. That is what we have for the requirements. And here's the evidence that the state brought you. Testimony from the victim himself, Mr. Duffy. Testimony from several officers and detectives. Testimony from Ms. Newborn, who was a witness in the car. And testimony from Officer Hooper, formerly Officer Hooper of Roswell PD, who is the cell phone analyst today who looked at the records. Our evidence also included body cam footage of the incident at both locations, both 911 calls, one made by the defendant, one made by the victim. The fracture match comparison between the bumper and the defendant's car. Medical records that were entered. Cell phone data that was looked at by Officer Hooper. And then actual pieces of the defendant's car. This is the evidence that the state put forward to prove hit and run. In a moment, the defense will come and talk to you about the case, their version of the events. I would request that you think about what makes sense. What is reasonable to you for what happened? I would ask you to think about the victim in the case and how the actions of the defendant have impacted his life and his two kids, and his relationship with his longtime girlfriend, and hold the defendant accountable. I'll come back and ask you to do that and to find him guilty.
Thank you, Mr. Hand. And for the defense.
Yes, Your Honor.
to share screen as well.
Okay.
This case isn't about Landon Christopher. This case is about Kayla Newmore. And how do we know that? And the state even knows it. The state told you in opening that there was a confession, that you would hear a confession during the course of this trial. But what they meant was the self-serving statement of an unindicted, uncharged third person. That's the only confession in this case. She's the only one who's confessed. And her confession puts her in the Toyota Highlander and at the scene of the crime. She puts herself there. She's drunk and high, and she puts herself at the scene. She confesses to all of it, except she puts Mr. Christopher in the driver's seat. I only get to address you once. I don't get to go twice like Mr. Hand does, so I do need to discuss the law that is going to be applied to this case. The state has to prove each element of the crime and in the indictment, and you will have a copy of it in the back. They have not given you enough evidence of the first part, which is while operating a motor vehicle. That's a requirement. A passenger doesn't have a duty in a hit and run situation. They do not have the duty to stay, only the driver does. So the state has to prove beyond a reasonable doubt that it was Mr. Christopher who was in the driver's seat that night. So the state provided evidence that there was a serious injury while operating a motor vehicle is a huge problem. Let's talk about the levels of proof. So Officer Bath told you that Mr. Christopher was not arrested that night because they didn't have probable cause to arrest him at that time. They had the car, they knew about the hit and run, but they didn't have probable cause to arrest him. They don't have much more than that now that they presented to you. But the state has to prove beyond a reasonable doubt, many steps, several steps above probable cause to arrest. This is to convict him that he definitely was the one in the driver's seat that night. Grave suspicion is not sufficient to authorize you to convict Mr. Christopher. So even if you are gravely suspicious that he was the one behind the wheel, you must acquit him. So the state also has to exclude all reasonable theories of innocence. Theory of innocence is he wasn't driving. You heard testimony that she drove him places. That's a reasonable theory of innocence, and the state has not disproven beyond a reasonable doubt. This is one that the state has already harped on, that a single witness, if believed by you, is sufficient to establish a fact. Not you can just base the whole case off of if you believe a witness, then that's the case. A single witness is enough to establish a fact, provided you, the jury, find the witness's testimony sufficient. You don't have to. That is your call to make, whether you find that person's testimony sufficient.
You are the sole determiners of witness credibility, and you heard and saw the witnesses in this case. You are going to be given instruction by the judge that in deciding this case, you may consider numerous things. I would encourage you to think about the only real witness that actually witnessed anything, which was Kayla Newborn, her interest in the outcome of this case. Let's talk about the reasons that Kayla Newborn is not a credible witness. She admitted on the stand that she came up with this version of the events last week. I asked her that and she said yes. She came up with this version that she told you last week. She's turning over text messages. She's cooperating with the DA's office. All of a sudden, when before she wasn't. This was a new development for her to be so cooperative all of a sudden. The state told you to use your common sense, please do. All of a sudden, she's working with the DA's office. There's not more going on here. She's not scared of Mr. Christopher. She called him after her breakup. She's still texting him, still sending him photos. She said they were in a relationship, but on body cam, Mr. Christopher says that that's his friend. So I think, unfortunately, once she did start cooperating, the DA's office, I imagine, had some questions for her about why the first story happened. And so she had to double down. And that's why she said those horrible things about Mr. Christopher. Because I'm imagining someone at some point said, why did you lie to start with? The truth is because she was driving, but she had to double down and say, it's because Mr. Christopher is a horrible person, essentially. Those are some difficult questions to answer from the district attorney's office who would prosecute you about why you lied. You got to come up with something. Another reason she's not a credible witness is the inconsistent story she told Katie Newborn. So the state called Katie Newborn, who pretty much impeached everything that Kayla Newborn had said. First of all, there was an elaborate plot to, I can't text you this about this. I can't talk to you on the phone. I have to drive 2.5, 3 hours to meet you in person to tell you. We don't know what she for sure told her, but we heard from Katie that she was told that Mr. Christopher had wrecked a red Explorer. She was very clear about that. Where did she get that information? What was she talking about? So either Kayla Newborn lied to her too, or she just didn't remember what happened. Katie Newborn also said that Mr. Christopher, and this is all coming from Kayla, her information. So Katie says that Kayla told her that Mr. Christopher brought a Jack Daniels bottle also, that they both brought a Jack Daniels bottle. The most important thing about Katie Newborn's testimony is that she told you that Kayla told her they did not know it was a person who was hit that night. Kayla told Katie they found out later and they thought it was a deer at the time. Kayla told you that there was some Mr. Christopher saw a body and all this stuff happened, but she told Katie sooner in time after the event than today that they didn't find out that until at least a day later, certainly not that day. That's huge. That is really, really important. Another reason that Kayla is not credible is because She lied. She lied to the police, and you saw video of it. The state played you video of their witness lying to the police. She wasn't arrested. Mr. Christopher was for the other charge. I'll leave you to conclude why that might be. He was arrested, not her. But another reason that Kayla Newborn is just not a credible witness is there are very real legal consequences for her on this. She falsely reported a crime. She gave false statements to the police, which we saw on video. And she was driving and didn't run. This is still very much within the statute of limitations. This DA's office could indict her for any one of those charges. And, you know, things are going really well for her. She said that she's been sober since June. She doesn't want to have to go to jail like Mr. Christopher had to. She doesn't want to have to keep coming back to court and be prosecuted. And I don't blame her. But the fact of the matter is, in December of 2020, she was a heavy drug user, as you heard. And she was the mastermind behind this whole thing. This was her crime, and this was her cover-up. The state brought a lot of evidence to show you that Mr. Duffy was hit and injured. He testified about it. You heard his 911 call. You saw the body cam of him at the scene. The state introduced medical records that you'd be able to look at if you need to. That's proof. That's how you prove to a jury beyond reasonable doubt that something happened. And what happened to Mr. Duffy is awful. We agree with that. He was injured badly. And you could hear the pain in his voice in that 911 call. But convicting Landon Christopher for hit and run is not justice for Mr. Duffy. You can't base your verdict on your sympathy, Mr. Duffy, although it is valid and completely rational to feel that way. You can't base your verdict on it and convict Mr. Christopher when there's not evidence that he was driving. It's not you letting Mr. Duffy down. It's the police investigation in the DA's office. So the judge is going to instruct you that your verdict has to be unanimous, and that's true. But you don't have to all agree about why there's insufficient evidence to find Mr. Christopher guilty. So let's talk about the examples of reasonable doubt. First of all, the state had a witness list and they called them witnesses, but nobody saw what happened. Nobody saw the accident. Nobody saw Mr. Christopher in the driver's seat. The only person who does that is very problematic and a documented, verified liar. And some of you, that may be your reason, that Kayla is just not a believable witness. You get to determine that. She has a demonstrated interest in the outcome of this case. And another reason is just you can find there's simply not enough evidence. You heard that they processed the car. They didn't bring you any evidence from the car, from inside the car. They brought you a bumper, but they didn't talk about fingerprints or DNA or who was where, if they could tell Didn't bring anything from, they took his car, Mr. Landon's car, and processed it, but brought you nothing about what was uncovered. Whether there were fingerprints sent to the GBI, nothing. So you've heard all the evidence. And if you're thinking, I wish there had been a video, like a video of the scene that shows what happened. If you think, then that's reasonable doubt. If you think there needs to be more evidence. And you've heard all the evidence. And if this is another charge the judge is going to give you. If your mind is wavering, unsettled, or unsatisfied, which it very well should be, that is a doubt of the law, and you must quit. So if you're back there thinking, feeling unsettled, feeling unsatisfied with the proof that the state provided about who was driving, that is reasonable doubt. If you think that maybe Mr. Christopher was behind the wheel, that's reasonable doubt. If you think he probably was behind the wheel, probably is reasonable doubt. And if you have those questions, look no further than the state of Georgia's table, because they have the burden of proof. So if you have questions about something, that is reasonable doubt. So the state gets the final word, and so I have to sit down, and as soon as I sit down next to Mr. Christopher, I'll think of other things that I should have highlighted, things that I should have reminded you of in the evidence, and I won't get that chance, which is why I so appreciate that you have listened, you have taken notes, you have asked very insightful questions, and you know what the evidence was. And you know to use your common sense and reason about what's really going on. Don't let the state make you forget what the evidence was and what it wasn't. The state has not proven that Christopher was driving that night. Mr. Christopher was driving that night. And no amount of cell phone data or bumpers can show you otherwise, can prove otherwise. Kayla confesses to doing that. No amount of any of this other stuff that the state claimed were witnesses and evidence can put Mr. Christopher in the driver's seat beyond a reasonable doubt, because he wasn't. We ask that you come back with the only verdict that the evidence supports, and that's not guilty. Thank you.
Thank you, Ms. Feely. Mr. Hand, if you want to transition back, if you're going to be using the screen, feel free to do that.
Put my laptop here so the members of the jury, the defense's tactic or strategy here is to sow doubt in your minds about the evidence that the state brought you. Distract, to deflect, get you to doubt. Their theory is, okay, this happened, you can't prove it. Their theory is this is her crime, her cover up. But ask yourselves, whose car was used in this incident? The defense wants you to believe that someone who was picked up at a gas station got not into the passenger side of the car, but got into the driver's seat, and that driver then switched and got into the passenger seat is when they drove off before this incident happened. How reasonable is that? Everyone knows if you get picked up by someone, you're a passenger. You're being picked up. They want you to believe that that bumper at the scene was not the same one that matched to the car. So don't just ask whose car was it, whose bumper was found. It was the defendant's bumper. Whose idea was it to lie to the police? It was the defendant's idea. Whose idea was it to text Ms. Newborn and express unhappiness that she's coming to give her truth to the court? That was the defendant. The standard is reasonable doubt. It's not some lofty standard made out by the defense. Now, there has to be evidence, and it has to exclude reasonable doubt. The state met that burden today. I started with this photo for a reason. There isn't a doubt that this is the Statue of Liberty. You can't see the whole photo. You don't have all of it, but yet you know what this is. You know, just like in this case, what happened. The defense stated that we can't prove beyond a reasonable doubt that the defendant was driving the car. Here's much of the evidence that we brought you today, right on that point. Officer Bath took the stand and told you that from his conversation with the defendant, he had the only key that he knows of to that vehicle. He's the only one with the key to the vehicle. Yes, he says he allows other folks to borrow his car, but yet he could not name conveniently anybody, any of his homeboys that he randomly mentioned, any of his friends, any of his close relatives who had borrowed his car recently. I don't know. I'm not sure was his statement. Very convenient. But also Officer Bath stated that it was actually his car. It was registered in his name. They checked his car, both of them. Everything came back valid. But specifically for his car, it was registered to him. As the owner of a vehicle, you know where your car is. You know who has your car. It's your mode of transportation. And for someone to say within the last 24 to 32 hours, 42 hours, that they don't know who had their car, they don't remember who had their car, that's an indicator. That's an indicator that they're trying to conceal that they actually had their car at the time, that they were driving their vehicle at the time. There's no evidence that Kayla Newborn was driving that car at that time. We heard from her. She specifically said that she's never driven this Toyota Highlander. She's never driven it. She stated also on the stand that she had her own car. So if she had her own vehicle, if they wanted to go somewhere, he could have gotten in her car if she wanted to be the driver. But it happened the other way around. He wanted to drive. She wanted to hang with him. So she entered the passenger side of his car that night. We also heard from Katie Newborn. Now, some of you all may have you may not like Ms. Newborn, may not like everything she said. You may not agree with the way that she presented certain information. But she said that she was told about this event. And she said that Kayla Newborn called her and told her what happened. She said Kayla Newborn came to her residence and gave her even more information about what happened. And she described how else would she know what happened on Old Dogwood Road, December 12th at 4 a.m. That's what you do when something shocking happens in your life. You tell someone. And you don't think about all of the intricacies of changing the story, switching the stuff. You tell them because you don't know what to do. And that is what Ms. Kayla Newborn did. She called her cousin, Katie, and she told her what happened. And she went in person and she told her what happened. Nowhere in the story did she say that she was driving the vehicle. Every time Katie said that the defendant was driving, and Ms. Kayla Newborn said the defendant was driving. Nowhere did that waver. both said the same thing. So the state had brought evidence showing that the defendant was driving at the time. And based on that evidence and a common sense perspective about that evidence, he was driving at the time his vehicle struck Mr. Matthew Duffy. Other evidence that the state brought you was the victim himself. That's evidence because it demonstrates that an accident, a hit and run actually happened. He told you he was walking home from work. He was hit by a vehicle. He didn't see it. He didn't see who was driving. But all he knows is he woke up and that vehicle was not there. He woke up and there wasn't an ambulance. There was another 911 call made, which could have been done even if the vehicle was driving away. There was no one there trying to help him find his glasses, make sure he wasn't bleeding, make sure his ankle that he couldn't move wasn't broken. No one was there. You heard from Officer Brake, who came and told you he was one of the first folks responding on the scene. He told you that when he looked at the victim, he had blood on his face. You saw that through the body cam. The victim told him he couldn't move his leg, it was possibly broken. And then he started looking around. And that's when we found the first pieces of evidence linking the defendant to this crime. We found his side mirror, which had the words Toyota on it, and a serial linking back to a Highlander. And we found a bumper piece that matched perfectly with his bumper, we would later find out. And we also found car parts. We also heard from Officer Batt more recently, this morning. Officer Batt told you that he answered another 911 call. That was to the church parking lot on December 13th at 9 p.m. What was reported was that the defendant's vehicle must have been sideswiped after he left his car there all day. Officer Brake, a rookie officer who just got on the force, immediately noticed the car. Now he did say that's our hit and run. He wasn't sure yet, but he immediately thought about it because that was the exact same car that he'd been told to look out for from the incident no more than 48 hours ago. He told you that he had conversations with with the defendant, and the defendant couldn't give a name of who had been driving his car. He couldn't tell in the last week if anybody had been driving his car beside himself. All he knew is he loans his car out all the time. He had it for a month, and he's loaned it out the whole month. Officer Batt also told you that after the defendant and Ms. Newborn drove away, he, Sergeant Fortunato, and Officer Lewis, which were the three officers in that parking lot, touched the hood of the vehicle. And that hood was warm on a December night at 9 o'clock, where all the officers had long sleeves, where the defendant himself had a hat on and long sleeves, where he thought the vehicle next to him that he touched was cold. This vehicle was warm. It had just been moved, maybe an hour ago, but certainly more recent than 10 a.m. that morning. Officer Lewis gave testimony as well. That was the second officer on the scene. Now he spoke to Ms. Newborn, and he asked Ms. Newborn, have you been with him all day? She said yes. She corroborated his story. He came back to her a second time and said, hey, we think this is involved in a hit and run. Here's your opportunity. Has this car actually been here all day? She said yes. He said, this car was involved in a hit and run. Her response was, not this car. I don't believe that it was this car. That was her response. And when she took the stand, she told you she lied to officers. She told you that she knows getting on the stand and admitting in front of you all today that she lied puts her in jeopardy because she could be prosecuted. The DA's office has not made any promises to her to not prosecute her. She knows that. But because she wants to tell the truth, because she knows she told a story, a lie to cover up this hit and run, she wants to come clean about it. She gains nothing from being here today. other than the truth. In fact, she loses something. She loses whatever protection she might have been able to have by lying about the matter. You heard from Detective Kowalski. Detective Kowalski has worked about 700 cases investigating and doing fracture match analysis or physical fit examination, as he termed it. He showed you exactly how those pieces fit together, from that bumper to that vehicle. They were a perfect match. He talked to you about macro comparisons and micro. It just didn't match in color, texture. It matched with small ridges to show the unique tear from that bumper to that bumper piece. He was very detailed. You also heard from Detective Romano, who told you that he wrote up the report and he looked at all the evidence in the case in order to take out search warrants. Now, Officer Romano added a supplement to this case that he shouldn't have added. Whether he misinterpreted Officer Hooper or whether he received the information incorrectly, somehow he put into the supplemental report that the cell phone records reflected that the cell phone was not in the area. But that's not true. And you know that's not true because you heard from Officer Hooper directly. And she told you she does this daily. She's investigated possibly thousands, or at least over 1,000 of cases where she's had to do cell phone data analysis. During her own analysis of the evidence in this case, she said that she can't tell where the cell phone was. In fact, there were no time logs for 4 a.m., which is when this incident is projected to have happened. Detective Romano, however, did say, based on the defendant being the owner of the vehicle, having the only key to the vehicle, based on the defendant never alleging any other person having access to the vehicle, specific name of a person at the time of this event at 4 a.m. on December 12th, that there was enough probable cause to take out arrest warrants. And he did. And the judge signed it and issued those warrants. You also heard from Kayla Newborn, who was an eyewitness who said, I saw the defendant driving the car. And she didn't just come clean about that, she came clean about everything. She had to take the stand and admit that she drinks alcohol irresponsibly, that she uses cocaine, that she's had to be in domestic violence situations. She's had to show a lot of information about herself that many people wouldn't share, just to be able to tell the truth. She gains nothing from this. So overall, this is what we knew before we heard from Ms. Newborn. We knew that there was a mirror left at the scene, had a serial number that matched the defendant's car. We knew that, we'll make a model of the defendant's car. We knew that there was a bumper left at the scene matching that car. We knew that that car was damaged in the front end. It was missing that mirror on the passenger side. We knew that the car parts matched based on the evidence from Detective Kowalski. We knew that the defendant had his only key, the only key to that vehicle. From the cover-up, we learned that the defendant reported that his car was struck, but conveniently there were no witnesses of that because he parked in an area where there were no cameras. We saw that there was no debris near that car to show that that car was actually hit there. We observed that there was no mirror, there was no bumper, which would have been laying around the car if it were actually damaged there. There's no broken glass. The car was still warm. And there was no evidence that another vehicle actually hit that car. Now we want to add in Ms. Newborn's testimony, which brings us all the context. He picked her up at the QT or the gas station, and he drove her around in Roswell. That was about into the morning of December 12th at 4 a.m. They were drinking Jack Daniels. using cocaine. They drove down Dogwood Road. In fact, you heard evidence from Officer Hooper that that car reappeared on Dogwood Road that same day around 1 p.m. The evidence showed that, per Ms. Newborn's testimony, that they did hit someone and that they saw the mirror was missing. They didn't stop, but they turned around to collect that mirror. And while they were looking for it, the defendant saw someone laid out on the ground. And he told Kayla Newborn to get back in the car so that they can speed off before the cops got there. He told Kayla that she had to turn off her phone. She didn't tell him that. He told her she needed to turn off her phone. He made her lie about that evening to police, and he chose where to park. And then later on, when he was released, Ms. Newborn testified that she thought it was over. She knew she might be prosecuted still, but she hadn't been contacted. And so she thought the whole thing was over. It was only until we contacted her and she received text messages from the defendant that she knew that this was a still ongoing prosecution, that she could get in trouble, but more importantly, if she told the truth, that the defendant could get in trouble. And so she made a choice. And she decided to tell the truth. Now, we heard from Ms. Katie Newborn, but she still corroborated several pieces of this story. That they were driving on that road, that they both were drinking Jack Daniels and cocaine, that they hit someone, wasn't another person or deer, but they knew that they hit someone. They went back to get that mirror. He told her to get in the car while yelling frantically at her. And then he told her she can't tell what happened that night. Katie added and said, Ms. Katie Newborn added and said, he told her that she can't tell anyone. She wasn't supposed to tell Katie Newborn either, but she did. The most important piece to me here is that Kayla Newborn is deciding to tell the truth, even though she loses the protection that she could have by not telling the truth. But this all comes back to why we care. Why do we care about holding someone accountable for this action? We can't have people going around hitting folks with their car and just driving away. Because if they know that they can get away with it, they know that they can cover it up by just calling a day or two later, saying they don't know what happened to their car, it was just damaged, that they could continue to do that without consequences. That's why we care. What the defendant did was terrible, but it was also devious. You injured someone and you tried to cover it up. You parked somewhere where you knew there weren't cameras because you intentionally did not want someone to investigate this to figure out what happened. We live in a society where we permit what we promote. If we permit this person to be able to do this, the defendant to be able to do this, we give everybody else license to do the same. The defendant doesn't get to cause a hit and run and cause someone to break body parts like their ankle and injure themselves. This defendant was found laying on the side of the road. And yes, he said listening to his call, he felt like it was a bit more dramatic than he remembered. But his words were true in that moment. He thought he was going to die. He was trying to move himself from the side of the road because he thought another car would come by and hit him again. Those were his true feelings. Also, you don't get to silence other witnesses and get away with it. The defendant told Ms. Kayla Newborn that she had to lie to police, not just not say anything, but she had to lie to police to cover up what he did that night. To cover up that she was there witnessing him hit somebody with his vehicle. That's why we care. We care, but we also hold accountable. So I'm going to ask you to look at all the evidence that we brought in today. Everything from all of the officers, from the victim to the witnesses, on down to the mirror that we collected the day before the defendant made his 911 call, saying that his car was hitting a parking lot, which we all know is not true. And I want you to come back with a verdict that speaks the truth. And that's guilty for hit and run. Thank you.
Thank you, Mr. Hand. So ladies and gentlemen, it's 4:15. I know that at least one, maybe several of you have the 5 o'clock cutoff as to when you need to get out of here for kids or pets or your evening shift. So I know we're going to stop now. There are two things left. I need to charge you. This is what it looks like. I need to read this to you. It's medium length. It's not interesting. It's late. And I don't know how much of it you'll absorb now. More importantly, you'll hear it tonight and then you'll come back tomorrow to deliberate and you'll say, wait, what did the judge say about hit and run? So I'm going to reserve this to be what we do first thing in the morning. I'll charge you first thing when you're fresh. And as soon as I finish charging you, you'll get this and the verdict form and the indictment and the physical evidence, and you'll be able to begin your deliberations. So you'll be off and running by 9:30, 9:45, assuming we start at 9. That is the plan. Does anyone have any questions about what remains? Any logistical questions? No? Anyone have trouble being here by 9 tomorrow? Let's repeat what we did today. It was good. Everyone was here on time. And again, the only thing left, there's not another witness someone can call, is for me to charge you, and then you'll get the evidence, select your foreperson, and begin your deliberations. However, the same instruction applies tonight. No outside research. There is no more evidence for you to get. So for you to read or look up anything is doubly inappropriate. One, it's happening outside the courtroom, but two, the state's done. You've got to decide this case based on what you've received, and it wouldn't be appropriate to augment it with anything. All right. Thank you so much for your time. We'll see you tomorrow, 9 a.m. for the charge, and then you'll begin your deliberations. Please take your pads with you and leave them in the jury room. You all can be seated. I had to change the jury charge because we only have, well, for an obvious reason, I had to take out false report of a crime, but there were a number of parts of it that said one or both or either count. I've cleaned that up. So I've got a new final version for both sides. Mr. Hand, anything we need to take up before we break for the day?
No, Judge.
Ms. Wood, anything from the defense?
No, Your Honor.
I would ask that you all, before you leave, review the physical evidence and decide what goes out and what doesn't. And I will stick around to referee it if there's a disagreement. And then tomorrow morning, we'll get on the record whatever that disagreement is. But that way, once I'm done charging the jury tomorrow, Deputy Gordon will have everything he needs to hand to them. So then we can go now off the record. And if the two sides would confer, we'll figure that out. Thank you.
Thank you, Judge.
One each. Thank you.
What are you saying?
What I think is continuing.
Oh.
And then you can-
Okay.
There's a muted, so
Oh, okay.
everything's in.
Thank you. This is good. Oh.
With that, just continue witness.
Note of these.
I'm gonna go, I'm just going over them. See if we're ready.
Yeah, putting them in two files.
Yes, this is going back, and that's what I can change on.
Says, 16.
Is it a file by itself?
Yeah.
I mean,
Oh, are you in this too?
I don't know, but
Okay. I mean, let me look at this and be like,
Right, yeah.
all that for an ankle, whatever.
You agree all this, right? It's just a matter of what should be.
Yeah, I'm just taking note of your. This is 15, 18. And okay, 18. Okay. We might want to restable this so it doesn't get.
What's the evidence?
Sorry, Judge. My little.
You and the clicking pen.
It's a